Good morning, how are you?
When do they start?
9:30 is my understanding. Are you here for the plea and arraignment or motion?
I guess they went to go get the inmate.
Uh,
How you doing?
I'm good, how are you doing?
All right. How you doing today?
Go ahead, all right, go ahead, I got it, go ahead, all right. This a copy?
The calendar right here. Yeah.
No, I say, it's a copy.
No, that's original. Did you get discovery on it?
I did, I just started looking.
Yeah.
At some point,
Yeah.
I'm about to-
Yeah. Why was, make sure all cell phones turned off for me. If you need to use it, you may step out of the court at any time.
Oh, good. Yeah.
I just get so negative, not negative, pessimistic when you.
Good morning.
Yeah, I'm sorry, I don't really remember.
I'm gonna go back.
How are you doing?
Yeah.
And like 5 times they're in that.
Suspended sentence. This happened.
I'll talk with him and see if that's something.
I did not want to call.
It's Division 20. It's Division 20.
So I got 2 different calendars today. Well, obviously it's showing.
Unfortunately, I do not. Yes. Terrence Miller. Yes. Thank you.
Yeah. So the PNA I saw in the system for 9:30, and then there's like a 1 o'clock motion.
Yeah.
Okay.
So that's why
I probably didn't have anything on that 1 o'clock.
that's why I want you.
I'm the Christiana.
He's the new Christian.
Okay.
I don't look as good, but I'm sorry. Bridges, Roger. Roger.
Good morning. Yeah. So once, did you, I didn't see that you had filed a motion. or
That's
you
why I
still-
called you.
Okay. I was out.
Okay.
So, yeah,
Oh,
yeah,
you're
yeah,
welcome.
yeah.
Yeah, we just provide argument. I'm looking for a trial. So, so I want to
Yeah.
give you the heads up.
Okay.
Make arguments.
Yeah, I mean, because I was researching that.
So we have I have a case I got in the first part that.
Good, how are you?
Way. For speed. This was all the charge, the time of the station. Same as in Mr. Brown's case, he wasn't perfectly like, but you know, they changed. Two openings. And charges were making sense.
Yeah, but I thought that it's. Yeah.
Yeah, it's straight through. So I kind of feel
Feeling okay. So. Good, thank you. So, I miss y'all too. At the moment.
Yes.
Okay.
So basically.
I guess.
Oh, and I'm gonna give it.
Yeah,
You know.
so there was that arraignment on
I'll
one
let
and
you look at it.
they weren't moving at the same
I
time.
forgot somebody's file. Yeah.
Thank you.
Landry's a male. I just need that. Landry. Number 4, for Hondonia. It says there's a motion for a bond, but I think that one was already heard. Well, I confused two because I got two. I get those two. You know how that goes. So I think one needed one and we had one.
Okay.
And I accidentally requested one.
Oh,
This guy did not follow. Position 14, Kylie Barnes. I don't know if you see it. I don't know how that works.
yeah, I do.
There Vincent Beasley here. What was Cosby?
Yeah.
Roger Cosby. Nick.
It's an arraignment. Okay. Here, I can take it. Go ahead and do that. Which one are you? The one that-
Much serious.
There's a FPA.
It's your monthly list.
And
I saw most people. Monthly.
Everyone, please make sure y'all phones are completely off on silent. Please do not let your phone go out for recording.
I didn't need it.
Okay.
Yeah.
Oh, yeah.
All rise. Superior Court of Fulton County, Atlanta Judicial Circuit is now in session. The Honorable Judge Charles M. Eaton Jr. is presiding. Court will now come to order.
Please be seated. Morning, how are you? Yeah. Okay. So we have some, so this is all plea and arraignments, Kathy?
Yeah.
Four, and then we have the three, the motions calendar after that. Okay, I'll do a quick calendar call. Pardon me? You know what? You don't need to do it on the record. Position one, Beavers.
Morning, Your Honor. Charles Webb here on behalf of Mr. Beavers. We have filed a waiver of arraignment. We also filed a motion for discovery.
Who has this with the state? Is it, okay. The motion, the discovery motion? Okay, the waiver. All right, so Mr. Bridges, you'll get them the discovery?
Yes, sir.
Okay. Do we have the waiver of arraignment?
Yes, it was
Okay.
filed.
Okay, we've got your waiver of arraignment. They'll get you the discovery, and unless you have any other questions, you're excused, Mr. Webb.
Thank you, Your Honor.
All right. Position two, Beasley.
Present on that, Your Honor.
Okay. Position three, Franklin.
Good morning, Your Honor. Jabari Jones. Is that Durante Franklin?
Yes.
All right, that's my case. We're ready on that bond motion.
Okay.
He's in custody as well, Your Honor.
Is the state ready to hear the bond motion? Pardon me? Domestic violence? All right, we'll give them a heads up.
If I'm not correct, I'm sorry. on Friday, we received an email that Ms. Iqbal tested positive for COVID, so she's probably not gonna be here.
Yeah.
In that case, Your Honor, we would still urge the court to hear the bond. My client's been in custody since May of this year. And she got attend via Zoom.
Well, let's think this through here, Mr. Jones.
Thank you, Judge.
Not a bad idea. Well, I was just gonna say, I mean, I'm not asking you to do a trial on the fly, but okay, all right, thank you.
Thank you, Judge.
Okay, position 4, Landry.
In custody, Your Honor.
I am present on that, Your Honor. That is for P&A.
Okay. And who has this with the state? Morning. Okay. Position 5, Mason.
Morning, Your Honor. This will be a not guilty plea this morning. We do have a motion for bond reduction.
Is the state ready to hear the motion for bond reduction? Okay, okay. Position 6, Campbell.
In custody, Your Honor.
And likewise, Your Honor, same announcement. We have a motion for bond.
Okay. All right, position 7, Deal.
This will be a not guilty this morning, Your Honor. I would like a chance to speak with Mr. Deal before he comes out, though.
All right. Position 8, Anthony.
I'd like to pre-try this with the state if possible. We could reach a resolution on this morning. Otherwise, we have a motion for bond reduction.
Okay. Position 9, Garland.
And this should be a not guilty plea this morning, Your Honor.
Ms. Marsh, you have this one? Okay, position 10, Bone.
That's this, where be it so.
Okay. Position 11, Brown. Courtney Jamal Brown.
That'll be for a not guilty this morning, Your Honor. There is the state's motion as well.
The state's motion. What's the state's motion?
88 million on behalf of the state. Your Honor, the defense did file a statutory demand for speedy trial.
I knew that.
Yes, ma'am. That is the only matter.
Okay. Did you say state's motion or defense motion?
It's the state's motion, is my understanding. I mean, I filed a statutory demand.
Oh, it's your motion addressing the statutory demand? Okay. All right. Apologies. Apologies. All right. All right, position 12, King.
Good morning, Your Honor. It's my understanding that my client has not been found. I know they believe she to be in Arkansas, but obviously because I've been appointed and this was a re-indictment, I've had no contact with him, but I know that there's an active warrant out for him. I don't know where.
Yeah, we've got this one on judicial hold. Give me 1 second. It says due to the issuance of grand jury warrant. Oh, yes, yes, that is part of Mr. Clark's issue. Okay. Co-defendant with Brown.
You said that this is all been placed in.
Yeah. He may be on there because he's a co-defendant with Courtney Brown, so we may have stuck him on there. But obviously, we can't address Mr. Brown right now. I see that, yeah. Okay. All right, position 13, Rockwell.
Your Honor, Mr. Rockwell is in federal custody right now in Mariana Federal Corrections Institute. So I would ask that this could be reset. I'm not sure when she's going to be. She was in Newton and now she's in federal custody.
It's been a moving target with getting that set up. Okay, we'll reset it. Position 14, Barnes.
I'm here, Your Honor.
Okay. Who's representing Barnes?
When she was initially arrested, Your Honor, she did not qualify for our services.
Oh, yeah, I remember. Didn't Mr. Harvey say he was going to talk to you?
Yes, sir. We had two conversations and then over the last couple of months, we played phone tag afterward. I know he was in trial for a while.
He's in the YSL trial.
The last I heard, he said he was gonna look at the reports that he had got from the VA.
All right, well, here's the deal, Ms. Barnes. I mean, I guess you're going to need to talk to Mr. Harvey, and if it's not going to work with him, then you're going to have to find another attorney because you're going to keep being called down here until eventually we're going to demand it come to a head. You follow what I'm saying? So let's. I'll continue it, but you're going to. I know Mr. Harvey's tied up in YSL. I'm well aware of that, but he does have opportunities to sneak up here and help on certain situations. So why don't you follow up with him one more time and I'll continue this, okay?
Okay, you want me just to update your office?
Well, he's going to need, I mean, it's just going to need to be a little bit more formal. I mean, either he's going to help you or he's not. And if he's going to help you, then he needs to file an entry of appearance.
Okay.
And then he'll be the attorney on record for you. And if he's not, then we'll figure out other options. Okay. All right. As of now, you're excused and we'll reset your case. All right. You can't be in between, either he's with you or he's not. That's what I'm saying. Position 15, Clark.
Present on this, Your Honor.
Is he here?
I don't believe so.
Have you had contact with him?
No, Your Honor.
All right, well, we'll circle back. Position 16, Poindexter. Yep, I see it right here. All right, that looks pretty straightforward. You're excused and we'll reset your case. All right. Position 17, Lee.
Brandon Thomas here, for Aubrey Lee, Your Honor. That is a FTA and motion to reinstate bond, and I suppose while we're here, we can do the arraignment. I was wondering if we might be able to go first, like have a phone conference with the U.S. Attorney's Office. For about 12 o'clock. I gotta get back to the office.
Okay, are you representing him on 18 as well?
No, Your Honor, the one that ends in a 2, I'm representing Lee on. The one that ends in a 0, I'm not retained on that case at this time. So that's an error on the docket. I didn't file an appearance in that.
Well, no, you're not listed as his attorney. Lawrence Lewis is listed as his attorney.
That's another thing. So they fired the previous attorney. That's kind of mixed up in my motion for bond that'll come out. The previous attorney, the reason why Aubrey Lee's in custody right now, they failed to change their address. So that'll come out in the discussion motion.
All right, we'll prioritize you. Position 19, Dorsey.
In custody, Your Honor.
And Your Honor, it looks like that might be mine. I believe Mr. Lohmeyer from the AG's office is
Yes,
here.
good morning, Your Honor. Greg Lohmeyer. I'm here from the Attorney General's office on behalf of the state. This is a failure to appear bench warrant, so he's here for arraignment.
Okay.
And I'd like to speak with him because Mr. Lohmeyer conveyed a possible offer of this, so I want to go communicate it to him, go and see him. See if he wants our services and see if what we can do on this case today.
Okay. Position 20, Anthony.
In custody, Your Honor.
So Mr. Gowdy's his attorney. Pardon me? I will circle back. We don't have Mr. Gowdy here. All right. All right, and we've got a couple add-on calendars here. So Prasad.
I believe that's gonna be a not guilty plea this morning, but I would like an opportunity to speak with him. In addition to that, it seems that Mr. Prasad has a couple of unindicted cases. I just want to make the court aware of. I don't have those CP numbers, but I can.
All right, when we break, you can talk. It looks like he's got the 3 here, and then you say there's some unindicted ones as well, huh?
Yes, Your Honor.
Okay. And then Cosby.
I'm present on that, Your Honor.
Okay.
That would be for Plea today.
All right. Okay, well, let's go ahead. So, Mr. Thomas, are you ready to talk about? You ready to bring Lee out?
Yes, yes.
Okay, go ahead and bring out Aubrey Lee. Oh, all right.
We're not ready yet.
All right, well, we're, so what did you bring him up in order?
Yeah, we brought them up in order, but some of them, we have issues downstairs.
But I mean, is he going to be brought up?
He's gonna be brought up.
I mean, here's what I'm getting at. Am I going to have to go on break before he gets brought up, or will he be brought up in the flow of things?
Probably best to break. Yeah, probably best to break. Like, we should probably break now.
All right, we'll take a break and hopefully get Mr.
You want him to go first?
Yeah, because his attorney asked for it. He's got federal court. And so let's go ahead and bring him up. We'll take a break.
Your client said, please, sir.
Oh, Mr. Laundry. And then,
I mean,
Ways and
you guys
Means,
take it down.
his hearings at 1 this afternoon.
Yeah.
Unless the
I ain't
judge-
never had to come up that point.
Yeah, unless, the court's ready earlier, but there's a private, so I'm guessing they will.
Is he taking the plea over?
Oh,
So, and the other person. So both of your
Yeah,
people are further notice.
yeah, there'll be further notice. He's
Landry.
got a rate.
But they are gonna be seen.
They'll should be seen by the judge.
Okay.
He's on strike.
Look at you.
So you don't need anything else?
I got one from his cousin.
I'm sorry, I don't know. I just wanted to say. That's why.
King, okay, King has a good additional.
I'm not mistaken,
Is that a deal?
Yeah, yeah.
that's why I knew it. And we're looking for.
But she might not want.
Yeah, because you represent her, right? Mr. Phillips? You represent
Campbell, yeah.
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 Albone. He said he's in.
Federal custody, my understanding.
Do you have,
I believe so. Mr. Miller may know about that. She's asking about Alpha.
Oh, already pled, maybe 2 months ago. I have to confirm with Mr. Burr, but from my understanding, he was already found guilty. He was just waiting for sentence.
That's
Oh. Sorry.
I got my forward on.
Oh, yeah. I gotta represent. I'm a Neo, so I have to,
Oh, Lord.
yeah, right. Triple Neo, all that.
Uh-huh.
I know you have upset with talking about it on the calendar.
okay.
I don't want to hold you up. so
No,
it's
no, I
okay.
appreciate it. Yeah, thank you. Yeah.
Just one minute. No, that's actually, it's, yeah, we already have.
Council, once we get them all up.
Are they ready?
No.
Okay.
We're still bringing them up.
last week. That was last week. They bought everybody that last week. Yeah. Right, last week was chocolate.
Well, especially if it's murder, felony murder. Yes. Yeah.
How many people? You got a lot of comments. I got a lot of. How many people take the police?
Probably maybe.
Which one? I ain't gonna write it down because you said
Possibly, well, and then possibly.
But the rest gonna be not. So I'm saying the rest gonna be same for the counties.
Most of them have bond motions, so bring them out.
Okay.
And have that information.
We all are. Oh,
You didn't need to go back and talk?
No, we're ready.
No? Okay.
What do you need?
Aubrey Lee. Yeah. Huh? No. On the stand.
Court come to order, remain seated.
Is Mr. Lee up now?
Okay.
All right, great.
Lee.
Yeah, you ready?
Yeah.
Right here, Mr. Lee.
Okay, this is 23 SC 186352. Aubrey Nicole Lee, who's present in the courtroom with his attorney Brandon Alexander Thomas. Mr. Bridges, do you have this case with the state? All right. And it sort of involves 23 SC 187550, although Mr. Thomas has made it clear he's not representing him on that case, but we'll talk through that in a second here, but go ahead, Mr. Thomas.
Yeah, before we get that, for the purpose of the day, can we actually get the arraignment done first? And actually, you don't be in a right, P&A for both cases.
Okay.
I'm fine with doing the arraignment on the case ending in a 2, but as I said, like I'm not retained yet on the case ending in a 0. So that's
Okay, so Mr. Lee, you're on the position 18. So do you have an attorney for that case?
I was planning on paying him just as soon as I got the first case resolved. It's been 3 years since any of the case I had.
Mr. Lee, I really, and I'm doing this for your own good, and that's why your attorney told you. I'm just asking procedurally what's going on with your attorney on the
I
other
was
case.
gonna actually proceed with him. I had an attorney.
Wait a minute, you talking about Mr. Thomas or you talking about Mr. Lewis?
Mr.
If I could, I think I can clear this up, Your Honor. It's a little convoluted, but the point is, Aubrey Lee has fired their previous attorney. And so, but the issue is though, Aubrey Lee has serious charges in both cases. They can only afford to retain me for the one case. So I'm retained on the one with the FTA, which is why they're in custody now. The hope is if they can get released on bond, they can get back to work and make some money and they can pay me for the second case. But as of now, I'm only retained on the one case, the one ending in a 2. And so that's the situation.
Your Honor, for limited purpose of the plea and arraignment, can he just represent him on that, just for limited purpose, not filing interest on just limited purpose, so you get the waiver and get that moving on, because we want these cases to travel together.
Talking about position 18?
Position 19. As I understand, he represents.
Well, maybe these positions have changed, but you're talking about the second case that he doesn't have an attorney on.
Yes, Your Honor.
Well, let me ask that. Mr. Thomas, will you, for the limited purpose of a plea and arraignment, do the plea and arraignment on the other position? I mean, it's your, if you're going to say no, you're going to say no.
Yeah,
But
I'm willing to do it, Your Honor, just with hopefully the understanding that the court's not going to hold my feet.
I'm not going to do that. No,
Okay,
no.
yeah,
That is not how
Oh, we can do it. We can do it.
I'm not here to trick anybody. If
No,
I
no,
tell
no,
you
no,
that
that's fine,
it's a
that's fine.
limited purpose,
That's
it's
fine.
a limited purpose. All
That's fine,
right.
Your Honor. Yes, Your Honor.
Okay. So we're going to do the plea and arraignment. Okay. So she's printing out the paperwork as we speak. Let me ask you this real quickly. So, Mr. Lee, do you mind being represented or do you approve being represented by Mr. Thomas on this 23 SC 187550 for the limited purpose of just this plea and arraignment?
Yes, sir.
Okay.
Sign right here. What's this defendant? Yeah. Sign right here. Okay.
Okay. So I have the 2 indictments. I have not guilty. Is that your signature, Mr. Lee, under both of the indictments under the not guilty?
Yes, sir.
Okay. So you were pleading not guilty. Okay, go ahead on the case that you're representing him on right now, the 23 SC 186352 case, Mr. Thomas.
Yes, Your Honor. So we are looking to have bond reinstated. This is something I haven't seen before, Your Honor. It's particularly egregious on the part of the prior counsel. I really think there's a malpractice claim here. In 2020, this court granted bond for Aubrey Lee and they were released on bond. There's 2 cases. They were released on bond for both of them. This is like kind of the pandemic era. There's been a break for about 3 years and there's been no court date. Aubrey Lee's previous attorney, Lawrence Lewis, moved his office address as is reflected in the motion, and he also confirmed that over email. However, the previous attorney never updated his address with the court. And so the court never gave him, he never got notice of the arraignment. And Aubrey Lee is calling the attorney saying, hey, when do I have court? And when do I have court? And they say, I haven't gotten a notice yet. Don't worry about it. I'll let you know. And so Aubrey Lee is relying on the attorney to let them know the court date. Now, of course, they're supposed to, the defendant is supposed to update their address with the court, and that is on them. It says it on the bond conditions, all of that. However, when you have an attorney and the attorney tells you, I'm gonna let you know when you have court, and they fail to update their own address, this is extremely egregious. They've been in jail for 60 days behind this. And aside from that, if the attorney, the FTA stems from an arraignment, which could have been waived. If the attorney would have gotten notice, he could have just waived the arraignment and there would have been no need for the FTA warrant. I've actually never seen a warrant issue when there's an attorney on the case like this. However, the defendant didn't show up, the attorney didn't show up, the court's not wrong. It's like at that point, it's like, well, let's just put out a warrant, we figure it out later. But we would respectfully request for the bond be reinstated. There's been absolutely no activity whatsoever, no new crimes committed, no violations of bond. It's literally the attorney failed to change their address, and both the attorney and the defendant didn't get notice.
Let me ask you this. You'd said, because this was June 1st, I have in my notes, no attorney or defendant. And you said you've never seen the court do that before. What did you mean by that?
No, excuse me, Your Honor. No, what I mean by that is normally, and again, I'm not blaming the court for this.
Oh, no, I'm not getting riled up. I'm just curious.
Normally when the FTA issues, it's when the defendant doesn't have an attorney. It's an unusual case where there's a failure to appear and there's an attorney. Normally, if the attorney would have come to court, something can get worked out, but he didn't come to court because he didn't get notice because he didn't change his address.
Yeah.
And the defendant didn't show up either because they changed their address. And so the court's not wrong. The court just had to issue the warrant. But it's written in the professional rules of conduct for the lawyers in Georgia. You have to maintain, that's a lack of due diligence. You have to change your address. You have to notify your client of the court date. The arraignment could have been waived.
Yes.
If the arraignment was waived, no warrant would have issued. So it's really egregious, Your Honor. And so that's why I'm here. I'm the new attorney. And they've been in jail 60 days behind this. They can't work. They own a salon, which they, gainfully employed. There's no felony convictions. However, there are 2 companion cases, but as I said, nothing new has happened. It's not like there's a new arrest or anything like that. It's just a failure to appear.
So Lee, is it Miss or Mr. or?
Mr. Aubrey Lee is a transgender individual. So I want to say the correct.
Well, I don't need to get into all of these.
I'm sorry.
So I'll just refer to as
Yes,
Lee.
please. I'm sorry. I apologize for not speaking. Raise my hand. I'm a transgender woman, so I go by Miss, if you don't mind.
I don't mind.
No.
All right. So Miss Lee, let's look this up. So Miss Lee owns a salon?
Yes, Your Honor.
All right. What is the state, Mr. Bridges?
Your Honor, I'm gonna leave this in your discretion. Counsel has shown me the records where the counsel admits that he failed to change his address, but Ms. Lee also has a responsibility to make sure the court has the updated address. So they are both responsible for making sure that that address is correct. I will say that what concerns with Ms. Lee is that she's a multi-state offender. I have Florida and Kentucky, New Jersey, with multiple cycles of arrest. That's the only thing that concerns me, Your Honor. But like I said, I'll leave you your discretion.
When was the bond originally issued?
I I have October 5th, 2020, Your Honor.
And there was no issues from that point till now, but except for the failure to appear.
That's correct, Your Honor.
How much is the bond?
1 second.
I see I just see a lot going on there in 20. 35. Looks like it's 35,000. Does that make sense? But then I see 1,000 here, 1,000 there, 1,000 there. I don't know. Don't worry about it.
I'm sorry, I don't have that. I don't want to tell you the wrong amount.
All right, I'll withdraw the bench warrant and reinstate the bond. Now, Ms. Lee, I know part of the reason lay people hire attorneys is to help navigate this process, and it can be intimidating, folks, but it is a condition of your bond that you keep your address updated and that you have to keep up with this as well. But it does seem like this was an egregious example, and we've got enough issues going on in the jail right now. So I'll agree to withdraw the bench warrant and reinstate the bond. Anything else?
Thank you, Your Honor. No, that's all. I guess the ring.
Yes, and can you send the order?
Yes, Your Honor, I'll do that today.
All right. Anything else?
No, Your Honor.
All right, you're excused.
Thank you. All right.
Thank you. Have a good day.
Hey, Mr. Bridges, are you going to be able to do the Franklin motion? All right, you ready, Mr.? I expect you are, right?
Yes, thank you.
All right, if you can bring out Franklin.
Yeah, I appreciate it. No, it's fine. I'm sorry.
Yeah, let's definitely do the plea arraignment, get out.
Yeah, we did waive, right? I thought so.
All right, so we're going to do the plea and arraignment first.
Yeah, we waived previously, Your Honor, so it's just on for a bond motion this morning.
Okay, go ahead with your bond. Well, here, so this is 23 SC 187918. Durante Antoine Franklin, who's present in the courtroom with his attorney, Mr. Jabari Jones. And we have Mr. Roderick Bridges representing the state. Go ahead, Mr. Jones.
Thank you, Judge. Mr. Franklin is 28 years of age. He's a native son of Georgia, born and raised here. He's got a lot of support here today. His mother is back here, and also his child's mother is back here in the over my left shoulder to support him this morning. I want the court to know he's been in custody since May of this year when he was arrested on this charge, denied bond at his initial hearing, and we filed shortly thereafter and finally in front of the court. Thankful for that opportunity. Appreciate the state for taking on this on such short notice. He's a graduate of Life Christian Academy 2014. He's been self-employed and as an auto broker, buying and selling vehicles. He's got some history in construction as well. He's got 2 children, both under the age of 5, and his youngest was born since he's been in custody. Very traumatic situation. Child was born prematurely, was in a prenatal unit, not prenatal, but the unit for infants, it escapes me right now, but it was kind of touch and go, but baby's doing a lot better now. Since he's been in jail, he's been attacked and had to defend himself 4 times. I'm thankful that he hasn't gotten any new charges due to what's going on. We all know the jail is in a deplorable state. I won't belabor the point of that. But he's not a significant threat to commit any additional felonies while on bond. He does have a previous assault charge that resulted in a felony charge. Outside of that, he doesn't have any felony convictions, Your Honor. This case would have been a misdemeanor were it not for that previous family violence conviction that I'm speaking of. And he would have been legally entitled to a bond at his first hearing. So, one could argue that but for the previous situation, he would have been out months ago. I was a little surprised that he didn't get a bond at his first hearing. I understand that it's still a felony charge, but in the scheme of things, it's not as serious as a lot of other felony charges. He's basically accused of grabbing or hitting, or if you will, his child's mother, who's here and can actually speak to that somewhat. He's not a significant threat to anybody's property or to abscond. He's not going to leave. I don't believe he has a history of FTAs, unless I'm mistaken. But if whatever measures the court wants to put in place, we'd be totally fine with that. He's not going to be intimidating any witnesses or get in the way of letting this case play out. He's perfectly content to let the process play out. He's not going to obstruct whatsoever. Not a threat to any particular individuals, and to the extent that the court may think that's an issue, we have his child's mother, who's the alleged victim, to kind of speak to that in terms of her, the non-existence of any fear or anything of that nature. I'll be asking the court to consider a bond, actually an unsecured judicial release. And I don't ask that lightly. It's not something I typically do, especially where a client does have some history and some contact with the system. But given the way things have played out, and this is not any calumny on the ADA today. However, previously I've never had such a difficult time contacting or getting a phone call back from ADA in over 10 years of practice. Usually I can get a phone call back and we can discuss a consent bond, especially on something like this, where the alleged victim has filed a sworn affidavit. She still has not been contacted from anyone from the ADA's office. Consent bond was not on the table. They're not entitled. We're not entitled to a consent bond. However, just keep the lines of communication open, I think would have resolved this before today. Yet here we are, and we're asking the court to consider an unsecured judicial release for those reasons. And then I have Ms. McMullen, who's the alleged victim. I think her testimony may take maybe 5 to 8 minutes if the court would be inclined to hear from her.
Mr. Bridges, do you have any thoughts on this before we hear from the?
As far as the victim, she's entitled to testify.
No, I know that, but I mean, do you have any overall thoughts on that?
Just reviewing the file here, I see that Mr. Franklin has 10 cycles, that's 10 arrests. He has 3 felony arrests. He has a felony conviction out of DeKalb County in 2018, which is very similar to the charges that he has here involving the battery, private violence, battery, aggravated assault, and false imprisonment. So he seems to have a history of this type of conduct. On this occasion, the victim contacted police after he had actually left her. Apparently, she said that he got into argument with her because she wouldn't give him any money. Threw her out of the car, dragged her to the car, and then actually slammed her head into the face of the car. And this is the way, I know counsel put it lightly, but this is the way he treated his child's mother. So, Your Honor, no, I do not believe that we could have consented to a bond, but I think the bond does need to be set in this case. And I will leave that in the court's discretion, how much bond.
All right, let me hear from the victim.
Okay. Ms. McMullen, would you please take the stand?
I mean, normally she can sit over at the witness box.
Yeah, that's what I thought was going on.
Okay, all right.
testimony is about.
Yes.
Please spell your first and last name.
JESSECAMCMULLEN.
State your first and last name.
Jessica McMullen.
Good morning, Ms. McMullen.
Good morning.
How do you know Mr. Franklin?
He's my children's father.
How many children do you have together?
2.
Okay. And you're aware of why we're here today, right?
Yes.
You and I have spoken on the phone previously, right?
Yes.
Okay, let's go back to the day in question that ended up getting Mr. Franklin arrested. What do you remember about your contact with him that day?
The day of, I called Mr. Franklin almost 200 times from private because he wasn't answering the phone. So I took it upon myself to call me an Uber to his home because I thought he had a female at his house. So I went all the way from Union City to Buckhead is where he lives. And when I got there, I realized his car was outside. That made me even more angry because obviously he was ignoring me because his car was outside. So when I got to his doorstep, I started knocking on the door and he still wasn't answering the door. So I started kicking the door to the point where
Let me stop you right there. Prior to your testimony today, have you had an opportunity to speak with a criminal defense attorney?
Yes.
And who is that person?
Miss Beverly J. Taylor.
How did you find that individual?
I looked her up on Google.
Okay, so it's not an attorney that I recommended to you?
No.
Okay. All right, so after you get to his house and you said you knocked on the door, then kicked on the door, what happened next?
I started kicking the door to the point where I actually knocked it off the hinges. So he finally came to the door, was like, what are you doing here? And then I stated, just talk to me. And he still wouldn't talk to me. So he offered to call me an Uber. And I was like, no, I declined. So he ended up taking me home.
So you guys got into his vehicle?
Yes.
And he drove you to your house?
Mhm.
Okay, was there any physical assault or any type of violence in the car on the way over there?
Yes, I actually was hitting him. I didn't tell the police that day because, of course, I didn't want to incriminate myself. But he didn't hit me at all. I was actually the aggressor. Like I didn't tell the police that because, of course, I didn't. Like I stated before, I didn't want to incriminate myself. I was the one who was hitting him. Once I got in the car, I realized that his nose was bleeding. I tried to kind of beat him to the punch, so I called the police.
Okay. And where were you when you called the police?
I was at my home at the time.
And where was Mr. Franklin?
He was still in the car.
Okay. At any point during this encounter, did he physically hit you, strike you, kick you, bite you, anything of the sort?
No, he was actually just trying to block my hits.
Okay. And as you testified today, are you afraid that Mr. Franklin would do violence to you in the future?
No, he's not even a violent person. Like I'm actually the aggressor, and it's crazy because like I actually been seeking therapy to help with my anger.
I understand. And has anyone from the ADA's office or the district attorney's office reached out to you to discuss this case?
No.
That's all I have, Judge.
Mr. Bridges.
Ms. Mullen, I'm sorry, Ms. McMullen, on October 28, 22, did you give a statement to police?
Yes.
And in that statement, you told police that Mr. Franklin assaulted you
Yes.
and that he slammed your head into the car?
Mhm.
And the basis for that assault was the fact that you would not give him some money.
Yeah, but
You gave it to police? Okay.
Yes.
How long have you known Mr. McMullen?
Mr. Franklin,
I'm sorry, Mr. Franklin, I apologize.
quite some time.
Was quite some time.
6, 7 years.
6, 7 years. So you're aware that he has a conviction for family violence in DeKalb County in 2018?
Yes, that's actually the same situation. I called the Uber to his home, beating on his door, the same situation. It's all leads to him moving on and being with other females.
I understand. And are you aware of the incident that the felony conviction he has for aggravated assault, false imprisonment, and battery, family violence battery in 2018?
That's the same case.
And you're the same victim, correct?
Yes.
And you say to state to the court today, you're not afraid?
No, I'm not afraid of him.
Okay. And did you testify, you gave statements in those other 2 cases, correct?
Yes.
Okay. Thank you.
Anything you want to follow?
No,
Okay.
agree, direct, Your Honor.
You're excused.
Okay.
All right. Mr. Bridges, I sort of asked for your comments earlier, but do you have any further argument?
Your Honor, based on the history, the victimology, out of state on the aggravated assault, I would ask for $100,000. On the battery, family violence, subsequent, which in this case is the third time, I think the maximum I can ask for is 1,000. I think that's still it's either aggravated felony, aggravated misdemeanor. So I think I asked for $2,500 on that one. That would take care of both charges.
And you're basing that on his previous cycles?
Yes, Your Honor, the same victim in each case. And of course, no violent contact or no contact with the victim in that case. I know they have a child together, so I assume there'd be no violent contact.
Any other?
And we probably need to send them to a men stopping violence, men battery winning clinic programs they have. Men stopping violence. That's a condition of honor.
How long is that program for?
It's usually 18 weeks, I think it is.
Okay, go ahead, Mr. Jones.
Yes, thank you, Judge. Just due to the unusual set of circumstances, it's not every day we have an alleged victim come in here and put themselves at some risk, albeit slight, in terms of correcting the record and what happened or what did not happen. I think it's of note that his entire felony history is linked to Ms. McMullen. Outside of that, I don't think that there's anyone who would say he's a violent person. So I would like the court to note that. And he does, from what I'm hearing, only have one felony conviction. The rest, either arrest or charges, did not result in conviction. So I would ask the court not to hold those against him. Typically, in a case like this, I may ask for a bond not to exceed $10,000 or so. However, I think that he's been in since May. He's already lost all of his opportunities to make money and support his family. He's got to play catch up. We don't want to put him even further behind the 8 ball by having him pay this extremely high amount, especially when we have sworn testimony from the alleged victim that the events that she gave a statement to police earlier are in fact diametrically opposed to what actually happened. Given that, I'd ask the court to consider an unsecured judicial release or a bond in the appropriate amount with either maybe a no violent contact provision, as she's testified she's not afraid of Mr. Franklin, or something closer to the unsecured judicial release. I understand the court has to do something, and we're fine with whatever it is. We just ask that he be allowed to bond out, Your Honor.
How long has he been in jail for?
Since May, remember the date?
The 3rd, Your Honor.
Thank you, May 3rd. Without a preliminary hearing, I also want to note that to the court. We filed for a preliminary months ago and have been following up. This may have been potentially resolved at a preliminary hearing as well, but hasn't been afforded that in 5 odd months. So it's just a comedy of either oversight, errors, or indifference to Mr. Franklin.
All right. You know, given the fact that, you know, and I know that doesn't always, given the victim's testimony, she seemed believable. And the fact that she hasn't been contacted by anybody yet, and it's been since May 3rd.
Your Honor, excuse me, we have contacted her 3 times. We called her. I checked in the records.
Okay.
Does it say they actually spoke to her or they just left voicemail? I know you don't know anything about the
Yeah, I'm
case.
sorry. I just looked at the records, saw that they had called her. The had called her.
Well, and I don't know about the phone tag, but I was concerned about the fact that nobody had even reached out to her. But Mr. Bridges, given everything I've heard and everything that's been presented, I'm going to grant bond on the aggravated assault of $25,000 and the battery fine with violence of $2,500, and that he enroll in the men stopping violence course that was suggested by by Mr. Bridges and that he have no violent contact with the victim.
Thank you, Judge.
All right.
All right, do I need to prepare an order or is the
Yes.
state, you want me to do it?
Yes, you
Okay.
you do the order.
All right, so just to make sure I have everything, he's got the bond on the aggravated assault, 25K, 2,500 on the other count, the man stopping violence course and no violent contact with the alleged victim.
Yes.
Okay, I'll get that to you in a couple hours at the most.
Okay. Thank you, Mr. Jones.
Thank you for hearing us out, Your Honor.
All right.
Have a good one.
Thank you, Mr. Jones.
That's all I have. May I be excused?
Yes.
All right, thank you, Judge.
And obviously, before you leave, I mean, I would think this goes without saying, but I want to say, I mean, there's any problems whatsoever with the victim, that there won't be any bond in the future. So, okay. All right. Thank you.
Thank you, Judge.
All right. All right. Ms. Jones, I see you standing.
Yes, Your Honor, I have on the supplemental position 1, Monica Cosby, and not guilty.
Okay.
Ms. Cosby, come on. Oh, I need to sit. Sorry.
Do you have the paperwork on that?
I do.
Okay.
What- okay.
Okay, this is 23 SC 187252, Monica Cosby, who's present in the court with his attorney, with her attorney, Ms. Tanya Jones, and we have Mr. Roderick Bridges with the state. Go ahead, Ms. Jones.
Thank you, Your Honor. My client waives formal reading of the indictment and pleads not guilty and will be further noticed on this charge.
Okay. So Ms. Cosby, this is your signature on this indictment. You're pleading not guilty?
Yes, sir.
Okay. All right, you're excused.
All right, thank you, Your Honor.
Thank
Be
you.
further noticed.
All right.
Do we have anybody else out there that can be addressed right now?
Cameron Deal, were you able to speak?
I
That's the
haven't
only
gotten-
case I have, Your Honor.
Huh.
Danielle Russell,
Quickly,
you
I
have
had
to
to
say.
go back.
All right. Do you need a minute to go back, Mr. Clark? I mean, might as well do it now than any other time. So look what I'm doing here for you. You don't even.
Mr. Bridges may handle it for me.
Oh, okay. And what's the case you got?
I've got Dorsey, Your Honor. It's an arraignment and the public defender was going to speak to him.
Pardon me?
The public defender was going to speak to him.
Who? Clark?
Yeah, I believe this. So yes, Your Honor. The gentleman that just walked out.
All right, I'll tell you what, I'm gonna take a break, but if he comes back out, make sure he's talking to Dorsey too, and we can handle all that.
I'm just covering for him.
right.
Yes.
Sure. Okay.
Yeah, when he comes back out, just make sure he's talking to Dorsey too.
Okay.
Thank you so much. I appreciate it. Have a good day.
Here, I'm trying to change it on there.
You can step out anytime. So you can do it. I just want to make sure.
Yeah, and then just change the numbers. Yeah, I'm sorry about that. Obviously, the one.
You should talk to him. You should like, hey.
I mean, she got this.
That's why you were like. He kept trying to, I can see you trying to, who are you?
She flat her wrist, you know, fight or flight. Tristan, he had you. Oh my goodness, that's funny.
Yeah, see that. You may not have. Right. See, right.
You gotta say that first time. This is the alpha dog. Yeah, it was the
When I had covered, and I'm like, wait, it's a. Smart people down here. Oh, yeah, she'll come.
Gave me the discovery via download. Problem with this is that the house. Don't get it.
And that's it.
You can share it with me.
She might have one more. Oh, I think I have that too. Yeah.
Okay, thank you. I'm going back upstairs.
The problem is, I'm sure you have the same problem too. Our H drive only has so much.
Yeah.
They are. So just share it with me whenever you get a chance. That's great. Okay. Perfect. But we're not gonna enter it on Thursday today. Yes. I got
We
your.
don't have anything tomorrow. They started. Then we
I thought he said, hey, I probably did. Hey, y'all, how y'all doing? Hey, Miss Kathy. How you doing? How am I doing? When is your birthday? I didn't hear no hello. You know, it's probably because I'm coming. Oh.
Share it rather, because that makes everybody's life easier that I'm not coming in that range.
No, yeah, that's.
Some of it will download.
bad, y'all. 'Cause I didn't stop what I was doing.
I wish. Probably be making better money if I was a free person.
Oh, that's what we talked about. I like spending time with them. Cause I didn't know what was about to happen around here. As I'm walking, I'm like, oh yeah, and there's a bond here, and I'm like, what? All right.
No. Hey, so I just talked with Mr. Dorsey. Is there any chance? Not that he's rejecting the offer.
Yeah. No.
I mean, because obviously it's absurd and it's not, it's about as good as you can do.
Yeah. My
We can do
concern
something, I
is that
forgot what
I think he's,
Get that age.
isn't he out of state now?
Oh.
He says he's living in Atlanta. He was picked up
That's very disturbing. All
essentially
right, well,
working
maybe
with
it'll come to me.
Good age, that's what happened.
on vacation. So, I mean, I'm just leaving him today. I can't.
I just have a hard time because it's actually twice that he's done a failure to appear. They did it once when he initially got arrested on grand jury. And I know it's COVID and all crazy stuff.
So he's already bonded out.
He bonded out and then he got set up for arraignment. I understand it's crazy timing, but we need to get it back on account.
I mean, I would ask, because really all I would want is have a chance to take a look at the discovery before, because this would make him a convicted felon. and
Right.
It's not, you know, that's my only caution. is
Sure.
If he already had a felony conviction, maybe.
Yeah. Yeah.
From my brief conversation, it sounds like. They're preliminary anyway, but I just feel like I need to do due
Sure.
diligence.
Yeah,
on it,
the only thing for you is it's a little bit complicated to look at the discovery because he basically went to the state website. Credit card numbers and bank account information, hack into it. When you go into it, it's like, I had a real hard time figuring out how they figured all this stuff out. So that's gonna get a little tricky and they don't have a summary. Actually, they do. The GBI did some work, so there's a decent summary, but when you get it, you're gonna go, wow, this is just, you know, a 3-page or 5-page police report. But I can get it to you as soon as possible. I'm retiring at the end of the month. Someone will take it over. I know they'll want to do the same kind of thing. I'll put some notes in the file. We have a very small office. But you know, whenever you can get it down for hearing.
I mean, if I ask. Roughly within that.
Sure.
That
Yeah,
time frame.
that's fine.
And that's, I think that's just. Oh, I would ask for that. as well. But that's.
Yeah, I really did. I mean, I get the whole point here. It's just, since it's been twice, I'm just worried that if we let them out now, it's gonna be another 3 or 4 years before it comes up again.
Okay, I mean, I understand.
But see what you, now that's my card. It's, everything on there is wrong,
Yeah.
basically, except the email. And those are my contact numbers now.
But I will.
You're gonna be able to represent him.
Yeah, I'm gonna be able to.
Tell me your name again, I'm sorry.
Bill Clark, let me, if I can get it.
Okay.
So what's going on there? I just recently got off here.
You just recently got it. All right, reach
I've
out to
asked
me.
these for a minute. I believe there was a multi, but I just.
Okay, so reach out to me, because these kind of things, like say we did, give us a test, reach out to me and see if we get everything.
There is one more that I'll reach out to you about. He's in Ohio. So he's but I think
I do just wanna go.
Send it to
ahead
me
and
if it's something I
wrap
can.
it up.
Yeah.
Be prepared to do that.
Okay.
Well,
I think that's one more. So I think we could maybe excuse that case.
Internal memo.
Okay.
You want to read that? That kind of just explains all to you. And the thing about this is what's happened since then. Unemployment benefits and the state was able to collect what was paid in restitution. Not in restitution.
So that's why I'm guessing all one thing is undeserved without.
Yeah, plus
probation.
it's just so old and he's
Yeah.
been out of trouble since 2019, you know,
Yeah.
so he's kind of done his probation, really.
Yeah.
But I do think it needs to be some type of proof, so we could do like 2 years suspended sentence, 30 days or whatever it is, reduced time served, something like that. I don't know. We'll be creative.
Okay, all right, and it's,
I think so, yeah, yeah.
all right, okay, all right, well, I'll go talk to them.
Yeah, okay, cool.
Yeah.
Yeah. Okay, yeah, she just talked. Of course, you made one else, right?
Yeah, that was your
Hey, counsel.
Yeah.
You know that one.
That's my age.
No, I don't know their name, but I was just asking the question because I'm running into a lot of people around here that went to school. Yeah, I ain't even started. when I say I'm running to a lot of people lately that went to school, where I went to school at. It's crazy.
I know my aunt was.
Sorry.
How about that?
Then look at me, I feel like I see you at home.
You know what?
I said, you look at me, I feel like I see you at a homecoming game.
I didn't go to that state.
Made me realize Georgia is not that big at all. Yeah. Go back down. Yeah. All right. He's right here.
Well, I'll check with Mr. Clark.
Yeah,
And if that's so, then I'll print it out. Okay. Oh, there. Oh, no, that's, I think that was my.
Yes. I'm sorry? Tomorrow? I haven't seen her, why?
Oh, she wanted to ask you a question.
Oh, well, I guess. Yeah, I just stepped out for a minute.
That's not fair.
On the jail charge. I need to check on that. See how long it's been. This could be something. I'll see. He has no felonies.
I know.
Court on order, remain seated.
I believe we're gonna have a negotiated plea as soon as Mr. Clark is time.
Oh, okay. All right. Well, I heard there might be some pleas. That was one of them. Okay. You know, the more time I spend out of the courtroom, the more productive things get, you know, it's. Okay. Which positions were those? Okay. Okay. Well, we can. I was gonna say, we could get Brandon out of here.
Much appreciated.
Is that the last one you have is DeJour Prasad?
Oh, yes.
All right. Do you just walk down here or do you?
Yes.
I need to go up there and use the cafeteria sometime.
They actually have a really good cafeteria. You know, there's the one at the Twin Towers and there's one by the old judicial.
Yeah.
But I've actually been really pleasantly surprised as far as cafeterias go. It's pretty good.
Yeah. Well, I used to work in that building. So. Now it seems like too big of a hassle to walk up there.
Right. That's right.
But I do recommend it to jurors. Not a whole lot else around here. At the state cafeteria? Huh. Huh. You did say we were ready for me to come out, right? Yeah, but that's part of his issue. We're gonna have to. We'll debate that this afternoon, but we're gonna figure out whether we're gonna bump something in the end of the month to try that case. His issue is his client's been in jail and they don't even know where one of the defendants is. We'll talk through that motion for speedy trial later today. Well, So for clarity on Courtney Brown, the state requested the hearing on a speedy trial. Is that correct?
Your Honor, the defense did file the motion for a speedy trial, and then the state just only had argument to oppose the motion.
Okay. All right. Y'all left me a little bit confused this morning with that, but. Well, I know the state didn't file the motion, obviously, but. All right. Let's go ahead and do Mr. Persad.
I think.
Okay, so we have three cases in front of us here. 19 SC 165519, 21 SC 179488, 21 SC 179490. All Dejor Prasad, who's present in the courtroom with his attorney, Mr. Brandon Hornsby Wilson. Mr. Bridges, you have all these?
Yeah, if I don't, I'll answer for all of them.
Okay, thank you. All right, go ahead, Mr. Hornsby Wilson.
So for all three cases, we're going to waive formal reading of the indictment and enter a plea of not guilty.
Okay. All right, so Mr. Prasad, I have three indictments here, then you're pleading not guilty on all three indictments.
Yes, sir.
Okay. And Mr. Hornsby Wilson, when we were doing the calendar call, did you say there's some unindicted cases with this as well?
Well, there's at least one unindicted case with this one, and I believe we're trying to have a global resolution for all of the cases. And I am not sure, but maybe the fourth one could potentially be accused. I didn't have the time to get the number while we were on break. But I believe my client is hoping for some sort of global resolution. And I think that that's something that we could potentially do.
How much time do you suggest to, when should we put him back down?
Well, I do have the discovery for three of the cases, as previously served by ADA Clark. I think the only, and I believe I have an offer for that case also. So I think the only hindrance would be the new case. And so I'm not sure, maybe we could have like a case management in 30 days to see where we are.
All right. All right, Kathy, can you put him down for case management or status or something in 30 days?
Yeah.
Okay, you're excused.
Your Honor, that concludes my business. I'll be excused.
You're excused. Is anybody out? Any?
One real quick one. Mr. Landry,
Where's Landry?
he is positioning for your DNA.
Okay.
That's who you want out, Your Honor?
Yes.
Yeah. Is that the only one you have?
Yeah,
It is?
for PNA.
Oh, that's right. You're coming back for the motions. Okay, that's right. Thought you were trying.
So I'll just be here. I'm not going back to the office. Too far.
I just thought you were trying to figure out how to escape or something.
No, this is just quick. So I thought then they,
We can get into
jail
that.
can be done and put them downstairs. I know they like to go back. No fun back there.
I don't think it's any fun at the other
No, I
place.
wouldn't say it's not fun either, but it's, I don't know. It's cold back there.
All right. This is 23 SC 188-234. Secondia Landry. He's present in the courtroom with his attorney, Ms. Tanya Jones, and we have Ms. Precious Marsh representing the state. Go ahead, Ms. Jones.
Thank you, Your Honor. As indicated, this is Mr. Landry. He enters a formal not guilty today and waives reading of the indictment. We have received discovery from the state and we'll just be further notice this time.
Do you have the paperwork? All right, Mr. Landry, you're pleading not guilty?
Yes, yes, Your Honor.
All right. Ms. Marsh, do you have anything to add? Yeah, I have that too. Is there a motion for bond or?
There is not, Your Honor. I mixed up one of my clients with my other client, but we already had a bond motion on that particular person. He already had a bond hearing in June and as I indicated to Mr. Landry, once I go over and review the discovery, we might file another motion, but not at this time.
Okay. All right, you're excused.
Okay, thank you.
All right, well, let's go ahead and do this Dorsey case. And are you done, Ms. Marsh?
No, Your Honor, unlike Attorney Jones, I am trying to escape. So if we could get Mr. Garland is my only other case, from my understanding, is a not guilty waiver as well.
Oh, okay. Well, since it's a not guilty waiver, we'll take that. Go ahead and bring out Garland, you said?
Yes, Your Honor, position number 9.
All right.
And I actually don't have paperwork on this. This is my mistake. I don't mind bringing him out to make the announcement. Oh, real quick? Yeah, okay, that's fine. Yeah.
What? You're trying to escape, you said?
Just a little, Judge, to do other work, to be fair, to appear other places, but still escaping a little.
Well, Brandon, he was upset. So I guess he wanted to go celebrate Columbus Day.
That's right, he gets it off
Jeez,
today.
Well, so do I. I think, I don't know. I'm technically a state employee, so.
Oh,
Okay.
yeah, we're county, so.
Also, you were supposed to be off today.
I was. My family's still down at the beach right now. So it's dedication. Okay, this is 23 SC 188819. Antoine Garland, who's present in the court with his attorney, Mr. Philip Clark, and we have Ms. Precious Marsh with the state.
Not guilty gives me a chance to actually.
I guess I'm a state employee that has to defer to the will of the county, but I don't know. I expect I'm not the only judge in the building. That's true. That's true. I just never knows. So why is formal arraignment crossed out as waiving on here?
I shouldn't have crossed out form. We are waiving formal
Okay.
arraignment. That's just a mistake, Your Honor.
Okay. Okay. So this, so Mr. Garland, you're pleading not guilty, correct? And I've got your signature here on this indictment. All right, you're excused.
Thank you, Your Honor.
You're excused. And now we can do Mr. Dorsey. Yeah. 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 Okay.
Yeah.
Start the game right here. Page 4.
Okay, this is 19 SC 173466, Michael Dorsey, who's present in the courtroom with attorney, Mr. Clark. And we have Mr. Lohmeyer representing the Attorney General's office. Mr. Lohmeyer, there's a negotiated plea to present?
Yes, Your Honor.
Okay, go ahead when you're ready.
Yes, Your Honor. So we do have a negotiated plea, and the terms of that plea would be 2 years to serve 30 days, reduced to time served. And we would ask that the balance be suspended, and I'll explain that as we go forward, Your Honor. As far as the factual basis for this case, Your Honor, this case happened back in 2019. At that time, Mr. Dorsey was under an obligation to pay child support, and he was making those payments to the Department of Human Services. They have a division that runs that sort of thing, and they have an electronic portal or an online payment portal set up. So what Mr. Dorsey did was he obtained credit card information and bank account information that did not belong to him, and was able to try or actually in one case did use this information to make a payment towards his child support. The first two payment attempts happened on February 4th of 2019. He used two different persons' credit card information. They both resided out of state, didn't know Mr. Dorsey. Those payments were not successful, but then a few days later on February 18th, he was able to get bank account information from two victims who have a joint account in South Georgia and was able to transfer $1,500 from their bank account towards his child support obligation. He also attempted to make a second payment from that account, but the victims discovered the first unauthorized payment and put a stop payment on their account. So it did not go through, and that was a $2,000 attempt. Mr. Dorsey was interviewed back in March of 2019 and at first denied doing this, but subsequently in July, he did admit to making the $1,500 payment using the victim's bank account information. And he also apologized and offered to pay back the money. And since that time, the money in fact was repaid because the state was able to recoup that $1,500 that was owed through unemployment benefits that they were paying him. So they got their money back. So that happened in 2019. He got indicted in December of that same year. And in 2020 was arrested, made bond, was released, and then did not appear at arraignment, which I believe was in October of last year. And so now we're here again today. He has one prior. That actually was a guilty plea that took place in 2019, which is around the same time all this was happening. It was in Cherokee County. It was to one count of identity fraud. He received first offender probation. I believe he has gone ahead and successfully completed that probation. So that's where we are right now. He's been in jail since, I think, September 9th. And it's been 4 years. The restitution's been paid, but it is some pretty significant charges here. So that's why we're willing to go ahead and make the offer that we did, Your Honor.
Okay.
Bard County in Florida.
And we're ready to go forward with the plea waiver. I just don't have the plea waiver form to actually read the rights to him.
Oh,
Yeah, he might have to borrow mine.
Oh, okay. I'm sorry. I thought that I was going to get a copy of it. So I apologize.
well, here, and here's the,
That doesn't have.
yeah, that doesn't have all of it
Oh,
on there. So
okay. All right.
They want to borrow his. And
Okay. All right. Thank you, Your Honor. We weren't expecting a plea today, but we're trying to
It's all
get
right.
this case resolved.
Yeah.
All right. Okay, Mr. Dorsey, if you would please raise your right hand.
Yes,
Do you
sir.
solemnly swear or affirm that the evidence you're about to give in the case of the state of Georgia versus Michael Dorsey charged in 19 SC 173466 shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand, please, sir. Please state your true, correct, and legal name for the court.
Michael Dorsey.
Are you now under the influence of any drug, alcohol, or medicine that could influence your ability to understand what's going on here today?
No, sir.
How old are you and how far have you gone in school?
I'm 33 years old and I went, my last thing was a trade school in Eagan, Minnesota.
Okay, so you're able to read, write, and understand the English language, is that correct?
Yes, sir.
Do you understand that you're charged with 4 counts of identity fraud and 4 counts of computer theft?
Yes, sir.
Do you understand you have the right to either plead guilty or not guilty to these charges? And if you plead not guilty or remain silent, you could receive a jury trial.
Yes, sir.
Have you reviewed the waiver of rights form with your attorney?
Yes, sir.
Did you sign that particular document?
Yes, sir.
Have you had enough time to speak with your attorney?
Yes, sir.
And as I understand it, Mr. Clark is your attorney?
Yes, sir.
Do you need more time to discuss the case with him?
No, sir.
Are you satisfied with his services?
Yes, sir.
Do you understand that we could waive this indictment, but you're going to go ahead and waive or give up the right to read that indictment? Is that correct?
Yes, sir.
Do you waive any and all defects in the indictment?
Yes, sir.
And you've been arrested on these charges, is that correct?
Yes, sir.
Has your attorney advised you the minimum and maximum sentence for each charge you're pleading guilty to?
Yes, sir.
And you understand that for each one of these charges for identity fraud, you could receive up to 10 years. And for computer theft, you could receive up to 15 years for each count.
Yes, sir.
you understand in pleading guilty to these charges, you're pleading guilty to a sentence than which you could be put on probation?
Yes, sir.
You understand that this is a negotiated plea, which means that the state is going to recommend a sentence of 2 years to serve 30 days, reduced to time served, as I've already explained, but that the court does not have to accept that recommendation.
Yes, sir.
And that you understand the court could sentence you to the maximum on each charge and could run those sentences consecutively to each other.
Yes, sir.
And you are not on probation at this point, is that correct?
No, sir.
Are you a citizen of the United States?
Yes, sir.
Do you have a firearm permit?
No, sir.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes, sir.
How do you plead to the charges of 4 counts of identity fraud and 4 counts of computer theft?
Guilty, sir.
Is this plea freely and voluntary given with full knowledge of the charges against you?
Yes, sir.
You understand you only have a limited right to appeal this guilty plea conviction?
Yes, sir.
Do you understand that you only have 4 years from today to file a habeas corpus petition challenge the constitutionality of this guilty plea?
Yes, sir.
And do you understand the factual basis that I gave to the court just a moment ago? And do you agree with that factual basis?
Yes, sir.
I believe that's all I have.
Can I see the
Oh, yes, Your Honor. I'm so sorry.
paperwork back now?
Yes, sir.
I was working at PacSun and Angie's. One PacSun, I was a sales associate, and Angie's.
All right, so you gave a factual stipulation earlier. Okay, Mr. Clark?
Yes, Your Honor. And what I'd offer to the court is obviously this was now over 4 years ago. Since then, I think Mr. Dorsey has straightened out his finances. What he informs me is that he's a sales associate at Outback Sign and also works at Angie's. Both of those are at Lenox Mall. He's still paying child support right now, according to him, and that's being automatically taken out of his paycheck at this point. And speaking with the state, Mr. Lohmeyer, it sounds like he has not gotten in any trouble since 2019. So I think what it sounds like is this is a result of some desperate circumstances where his license was suspended for back child support, and he made, I think, a mistake. And so we are asking the court to consider accepting this plea. He's actually been in custody since August 26, he informs me, when he was arrested in Brevard County, Florida, before being taken here to the Fulton County Jail. I'd also note, obviously, I'm getting involved today. I've discussed this decision with Mr. Dorsey. I haven't had the benefit of reviewing discovery on this, but I'm going over the plea offer with Mr. Dorsey. This was the decision he wanted to make to go ahead and resolve it today, and I do believe the state is making a very favorable offer. So I just wanted to put that on the record as well. But other than that, we're asking the court accept the plea recommendation.
What was the reasoning behind the failure to appear?
I'm not sure, Your Honor. I talked with Mr. Dorsey about that. At least according to him, he wasn't aware of the court date whatsoever. So I know it sounded like there may have been more than one failure to appear on this case, and I'm not sure if it was an address thing or what. But yeah. Obviously, it was not his desire to be spending any time in jail on this, and he doesn't have any outstanding warrants or anything of that nature. So there's no reason for him to evade court. It just sounds like it was inadvertent.
That happens sometimes. Hopefully there won't be another time, but if there is, it's up to you to stay updated with the court on your address, okay?
Yes, sir.
But
Yes, sir.
hopefully that's a moot discussion and
That won't happen again.
There won't be any issues in the future. Okay, Mr. Dorsey, do you understand the nature of the charges against you?
Yes, sir. Yes, Mr. Mr. Judge, Mr. Eaton.
Okay. You've just heard from the Attorney General's explain all the rights you give up by entering this guilty plea. Is it your wish to give up these rights and have this court accept your plea of guilty?
Yes, Mr. Eaton.
Do you understand that the court is not bound by the recommendation or the plea agreement, and I can sentence you as I deem appropriate?
Yes, sir.
Are you pleading guilty because you are in fact guilty?
Yes, sir.
Mr. Clark, you satisfied that that your client is competent in understanding that the plea is voluntary, that there's sufficient factual basis for entering the plea?
I am.
Okay, I find there is sufficient factual basis for the charges. I also find your plea of guilty to be knowingly, voluntarily, and intelligently entered. I will accept your guilty plea and recommend you and sentence you to the recommended sentence as follows, which is a global recommendation for all of the counts. 2 years to serve 30, reduced to time served, and balance probated. Is there anything else?
I believe the balance was also to be suspended as well.
Balance suspended. It was not probated. Balance suspended. Anything else?
Nothing further, Your Honor.
Okay, you're excused.
Thank you, sir.
So are you. All right, what one do you? Mr. Lohmeyer. What one do you want to do next?
Could we do Kendall Mason, Your Honor? His mother's here.
Okay,
His position.
Mason, Your Honor.
bring out Mason. I think it's your show from this point forward, so
So, yes.
I'll let you call the shots then.
Mason.
Just a not guilty plea bond motion.
Oh,
I knew I should have gotten specific with those counts. I knew I should have gotten specific with those counts because I don't think you can enter it into the disposition the way that I did. Okay, this is 23 SC 1888505 Kendall Mason, who's present in the courtroom with his attorney, Mr. Philip Clark, and we have Mr. Roderick Bridges representing the state. Go ahead, Mr. Clark.
Yes, Your Honor. Mr. Mason would waive formal arraignment and his not guilty plea.
This is Kendall Mason. All right, Mr. Mason, this is your signature on the indictment here, and you're pleading not guilty?
Yes, sir.
Okay, we will get you on the calendar, but you're excused.
Oh, and Your Honor, we did have a motion for
Bond reduction. Okay. Go ahead, Mr. Clark.
Yes, Your Honor. We are asking the court to reduce bond. As noted in my motion, it is currently set at $40,000. Mr. Mason has been in custody since December 2nd of 2022. That bond was set, I believe that was back in March for $40,000. He has been unable to make that bond. His family's been unable to make the resources for that. His mother is present in court today, Ms. Arkisha Manson, in support of Mr. Mason. Your Honor, what I can tell the court is he is 25 years old. He has no prior felony convictions whatsoever. Prior to his arrest on this, he was doing work, essentially doing some Instacart independent work as far as door delivery, things of that nature to make ends meet. If he were to be released on bond, he would be staying at 1119 Medellin Street in Smyrna, Georgia, apartment I-8. That is his brother's address. But what I can candidly let the court know is in speaking with his mother, it sounds like she's also working to try to get him into some sort of residential program for young men. We would ask the court, given the fact that he has no felony history whatsoever, to consider reducing his bond into the amount of $10,000. I believe that would be, obviously that's a substantial deviation, but I believe that would be able, the amount that would allow the family to post bond at this point. Other than that, Your Honor, he does have family. He's from Atlanta. His family resides in Atlanta. We don't believe he'd be a flight risk whatsoever if he were to be released on bond. And currently there is a requirement on those conditions of GPS monitoring. So that's already in effect, Your Honor. So we would just be asking the court to reduce the bond amount to allow Mr. Mason to be released while we're working through this. The other thing I'd note for the court is I still haven't received discovery on this case yet. I'm sure Mr. Bridges will work to make that available, but that's the position we're in right now is he's been in since December and we're still working on getting that.
I mean, it looks like in March, he had 100,000 bond, then it got reduced in July to the 40,000.
That may be correct, Your Honor. Yes, I didn't have the motion in front of me.
Okay, Mr. Bridges.
Your Honor, I haven't heard any change in circumstances. I would note in this case, we have spoke to the victim in this case, who does not know the defendant. This was a random meeting where the defendant approached the victim in the car, asked the victim to move his car. Victim said he didn't know what was going on, and all of a sudden, the defendant started shooting at his car and put 6 bullets in the car. So our concern is the violent nature and the random violent nature of it.
And I don't have much to counter the facts as we haven't been given discovery. I understand that was the statement made, but I'd note that it appears to have happened in a public place. So there may be video surveillance footage of that.
I mean, given the fact that he came in March and he was given 100, and then in July it was reduced to 40. I mean, there hadn't been a change in circumstances. I'm not going to grant the motion to reduce bond and leave it at the $40,000.
Yeah, sure.
Okay. Let's see here. Yeah, sure. We'll bring out Campbell.
You have the paperwork for Ms. Campbell?
I do, yes.
So you do have a motion?
Yes.
That's what we want. Oh. Campbell. Where you got Campbell?
Further notice for Campbell. Yeah.
No, right
Ms.
here.
Campbell, just
Okay,
right here.
thank you.
Yeah.
Straightforward.
Okay,
Not guilty, just-
In 1 minute here.
okay. All right,
That shirt. You might have your phone.
yeah.
Okay, this is 23 SC 187888. Maya Campbell, who's present in the courtroom with her attorney, Mr. Clark. And we have Mr. Bridges representing the state. Go ahead, Mr. Clark.
Yes, Your Honor. Ms. Campbell is going to waive formal arraignment, enter a not guilty plea. May I approach?
You may. All right, so this is your signature on here and you're pleading not guilty, Ms. Campbell?
Yes, sir.
All right, go ahead, Mr. Clark, on the motion for the reduced bond.
Yes, Your Honor. And we are asking the court, I actually said it as a motion to reduce bond. Since that motion's been filed, I think I need to, I guess, amend it to a motion to set bond. What I can let the court know is that Ms. Campbell has been in custody for 822 days at this point in time. She was indicted within the last few months. I believe her most recent bond set was back in April, setting a $2,000 bond on the charge of aggravated assault. I've been in touch with her family. Her family is trying to post that bond. Their plan for her is once she's posted is that they would take her to Peachford for some residential mental health treatment immediately upon her release. What I'd offer to the court is that Ms. Campbell does have a history of mental health issues. She was once an actress and a relatively prominent one back in the mid 2000s. Her life has been somewhat derailed by both mental health issues and kind of comorbid substance abuse issues. She has been in custody, as I stated now, over 2 years at this point in time. It took an extended period of time for the state to indict this case. And she is prepared to get out, and her family has been there for her and has a plan for her. The problem they ran into on this $2,000 bond is that the state had indicted her with an additional count of aggravated battery that the jail was holding her on because no bond had been formally set for that. So while they were prepared to get her out on a $2,000 bond and had all the I guess the safeguards in place that they were going to take her directly to Peachford, they weren't able to do so because of this aggravated battery count. So we are asking the court to set a bond on the aggravated battery count 2. We would ask for no more than $1,000, given the low nature of the bond so far. And we would ask the court to consider setting that to facilitate her getting out, getting some mental health treatment while this case is pending, and especially given the incredibly long time that it's been pending where Ms. Campbell has been in custody.
Mr. Bridges?
I have one question. Is that residential treatment?
Peachford, yes.
Your Honor, I would stick to the bond and that amount. If the condition is that she's released into the care of the court wants a little factual basis. This is an incident where stabbing another individual in the chest. Does not know her, does not know what brought about the attack. He actually is, and then she does have 17 cycles. So she has been in jail for quite some time.
So walk me through this, Mr. Clark. If she gets the bond, how does that happen where she ends up at the drug treatment facility?
I guess there's two options to go about it, which one would be a transport from the sheriff's office or to be released to her family who would take her immediately there. Which as I've been communicating with them, they would, but then I guess it's the court's comfort level, whether it would release her to her family. The only other option I can see would be a sheriff's office transport directly there.
All right, I'll I'm just reading the conditions of the last bond is what I'm looking at. I'm going to agree to the state's consent to the $1,000 bond, so it'd be a total of 3 for the, what charge was added? The battery.
It's an
Okay.
aggravated, yes.
So I'll agree to that 1,000, but let me just look at these conditions that we need to make sure that we're. How long's the program?
I mean, it essentially it's going to be, I think, I want to say 2 weeks to a month stabilization. And then she would be participating in outpatient after that.
It's longer than that. It's like 6 months. Yeah. It's longer than that. It's like 4 months. It's about 3 to 4 months. I know the doctor very well.
Okay, like I said, I'll agree to that bond amount. Some of the conditions they have, just want to reiterate the conditions that are in the 2000 bond order that I agree with. No contact directly or indirectly with the victim, victim's family, professional, personal, or close associates by phone, mail, email, or through a third party, including at victim's workplace, church, home, and daycare. If you encounter the victim, you must leave immediately and not come within 200 yards of the victim. No drugs without a valid prescription, no alcohol, no weapons. So what happens once she's finished with the program if we haven't addressed this case?
If we, once she's finished with the program, I think she would be out on bond at this point. And I'm not sure if we haven't come to some sort of final resolution on this case. Is that what your Honor is
Yeah.
asking? I think at that point, hopefully the program would have had a beneficial impact on her and we can continue to, track the case as it moves towards resolution. But if she's successful, I'm not sure what impact that would make on the state's.
All right, well,
disposition on
just
this.
she's to engage and she's to, complete the mental health treatment and follow obviously any recommendations that they propose. Anything else?
Nothing further, Your Honor. Thank you.
Okay, you're excused.
Thank you.
How should it be transported? Are we gonna-
So I'll let the family transport her. I will let the family transport her. Seems like Mr. Clark's engaged with the family and who do you want to do next?
Cameron Deal.
All right, Cameron Deal.
He's not here.
Let me get this to deal.
Okay, this is 23 SC 188-407. Cameron Corey Deal is present in the courtroom with his attorney, Mr. Philip Clark, and Mr. Bridges. Are you representing the state? All right. Okay, go ahead, Mr. Clark.
Yes, Your Honor. Mr. Deal will waive formal arraignment today and or not guilty plea as soon as I get the signature. I'll present that to you.
All right.
May I approach, Your Honor?
You may. All right, Mr. Deal, this is your signature on this indictment? And you're pleading not guilty?
Sure.
Yes, sir. All right. Okay, anything else, Mr. Clark?
Nothing further, Your Honor.
Okay, you're excused, Mr. Deal. Who do you want to do next?
Your Honor, I believe we're gonna have a plea on position 8, Mr. Anthony.
Okay,
So I'd ask if I can.
all right.
You need to go back.
Yeah,
You need to go back?
I do, yeah.
All right.
I believe we still have two, have Mr. Anthony Brown, Your Honor.
Or Brown.
And the other two guys, they come back at 1 o'clock, correct?
I don't believe Mr. Clark.
You were going to probably need a bench warrant on Mr. Clark.
And now we probably need bench warrant over to Mr. Vincent.
He never showed up either. All right, we'll do bench warrants and bond forfeiture on Beasley and Clark. You'll get me that paperwork, Mr. Bridges?
Yes, sir.
Give me 1 minute on that. I'm just making some notes real quickly here. Okay. Let's go to Zoom.
I'm on.
All right, Ms. Cabrera, is Bone in the? Where's Mr. Bone?
He is in Arkansas. He's in federal custody.
Okay. All right, so this is 23 SC 187734. And we have Mr. Bone, who's not present. He's in Arkansas in federal custody, but we have his attorney, is it Miss Cabrera Diamore?
Demore.
Demore. What did you have to say, ma'am?
I would otherwise be entering a plea of not guilty, waiving formal arraignment and asking for 10 days to file any motions. As I understand, it's a re-indictment. He was calendared before. He was in federal custody then as well.
So you'll get us that paperwork waiving the plea of not guilty and the waiving formal arraignment?
Yes, I can. Does your honor have a form order that he uses, or would you just like me to send over my own waiver of arraignment?
You can send over your own.
Okay, I will, your honor. I'll have that filed later today.
Okay.
All right.
And you'll get her discovery?
Yes, Your Honor. I did send Ms. Cabrera Demore the discovery several weeks ago via evidence.com. However, if there are any issues with her having access to those materials, I just ask that she let me know and I'll cure those problems.
Absolutely. I think we're fine. I don't think the evidence has changed. It's just it's re-indicted. Unless there's other evidence, I think I have everything.
Okay. All right. Well, unless you have anything else, you're excused.
Thank you, Your Honor.
All right. Bye-bye. Did Gowdy ever show up on Nicholas Anthony? Pardon me?
That'll be, she's in pre-indictment, Your Honor, in our office, so I'll be handling both Mr. Anthony's cases.
Oh, that's right. He has another case further. Yeah, that's right. You're bringing him out now. You got that paperwork? Oh, you're looking at it. Okay, there's two cases, 23 SC 187946 and 23 SC 187636. Both Anthony Nicholas, or Nicholas Anthony, I apologize, Nicholas Anthony.
I believe, I think there's some confusion, but his name is Anthony Nichols, is what he informs me. I know he's had a previous case under that.
And what's the spelling of that?
CHOLS.
But he would also concede that he's the same individual in the indictment that's named, so.
Okay. Okay, so Anthony Nichols, who, as you just said, is conceding he's the same person in both of these indictments. He's present in the courtroom with his attorney, Mr. Clark. We have Mr. Bridges present with the state. And you have a negotiated plea that covers both of these, correct, Mr. Bridges?
Yes, Your Honor.
Okay, go ahead.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter correct currently before this court
shall be the truth, the whole truth, and nothing but the truth.
Yes, sir.
State your correct, true, correct, and legal name.
Anthony Nichols.
Are you also known as Nicholas Anthony?
Yes, sir.
Are you at this time taking under the influence of any alcohol, drugs, or medication?
Yeah, my site med.
I can't hear you.
My site meds, run.
He's gonna have to speak up a little bit. I cannot hear him.
It's my medicine,
Which medicines are those?
run. I take run 15.
Okay.
For mental health.
Have you been given that medication today?
Yes, sir.
Is there anything about that medication that will prevent you from understanding the proceedings today?
No, sir.
Are there any other medications that you're supposed to take that you have not taken today?
No, sir.
How old are you and how far did you go in school?
I'm 30 and I have my GED.
Okay. Are you able to read, write, and understand the English language?
Yes, sir.
Do you understand that you are charged with the following? Under indictment number 23 SC 187946, unauthorized possession of a prohibited item by inmate, which carries a 1 to 5 year prison sentence. You understand that?
Yes, sir.
You understand that in 23 SC 187636, you're charged possession of meth with intent to distribute, possession of MDA, MA, and possession of marijuana with intent to distribute. All three can carry a maximum of 30 years in prison. You understand that?
Yes, sir.
I believe the indictment only had possession with intent.
And I might have wrote it down wrong.
The indictment just has the one count of possession of meth with intent.
I apologize. I went into the system and pulled this. How do you plead to the one count of possession of meth with intent to distribute?
Guilty.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, sir.
Have you reviewed the waiver right form with your attorney?
Yes.
Have you signed those as forms and those are the forms we have before the court?
Yes.
Have you had enough time to speak with your lawyer, Mr. Clark, about all the facts and circumstances known to you regarding the charges in these indictments and including any potential defense?
Yes, sir.
Do you need more time to discuss this case with your attorney?
No, sir.
Are you satisfied with his representation?
Yes, sir.
Counsel, do you waive formal reading of the indictments?
We do.
Do you waive any defects in the indictment, including name?
We do.
The state is unaware of any outstanding warrants related to these charges. Counsel, do you or your client know of any outstanding warrants related to these charges?
I do not.
Mr. Nichols, do you understand that this is a negotiated plea of guilty, which means that the state will make a recommendation to the court of a sentence of 10 years to serve 1 year with the 1 year commuted to time served and other conditions such as no drugs and alcohol, drug and alcohol evaluation. You've got your GED, but maintain gainful employment. You understand that?
Yes, sir.
But do you understand the court does not have to accept this recommendation? The court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other.
Yes, sir.
Do you understand? I'm sorry. Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on entering a guilty plea today?
Yes, sir.
Do you understand that if you are placed on probation of any kind, you cannot violate any laws of any governmental units or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, sir.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, sir.
Mr. Anthony, are you a United States citizen?
Yes, sir.
Okay. Do you understand that neither the court, your attorney, nor the district attorney has anything to do with parole, the Department of Correction, our partner parole, our board of parole, and no one can guarantee you parole no matter what you've been told?
Yes, sir.
Do you understand that there may be other adverse or unfavorable consequences as a result of your guilty plea conviction, just as there would be if you've been found guilty at trial? For example, your guilty plea may affect your ability to vote, your right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to possess or transport a firearm, or may impact your ability to get employment.
Yes, sir.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or used a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison.
Yes, sir.
Do you understand that you waive any and all rights, all defenses, including any mental health defense by entering a guilty plea today?
Yes, sir.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or remain silent and not incriminate yourself?
Yes, sir.
Do you understand that by pleading guilty, you are giving up the following rights: the right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assist the counsel hired by you or court-appointed counsel if you cannot afford an attorney at trial, the right to presumption of innocence, the right to testify on your own behalf and present evidence, the right to subpoena witnesses, compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if you're convicted of these charges.
Yes, sir.
Has anyone forced or threatened you or promised you anything to enter a guilty plea today?
No, sir.
Is it your decision to waive these rights and enter a guilty plea because in fact you are guilty?
Yes, sir.
How do you plead to the charges of indictment number 23 SC 187946 to unauthorized possession of prohibited items by inmate?
Guilty.
How do you plead to indictment number 23 SC 187636 possession of meth with intent to distribute?
Guilty.
Is these guilty pleas freely and voluntarily given with full knowledge of the charge against you?
Yes.
Do you understand that you may have only a limited right to appeal this guilty plea?
Yes, sir.
Do you understand that you have only 4 years from today to file what we call a habeas corpus, challenge the constitutionality of your plea?
Yes.
Your Honor, had this matter gone to trial, we would have shown that December the 25th, 2022, while an inmate at Fulton County Jail, 901 Wright Street in Fulton County, Mr. Anthony was found in possession of a latex glove. That latex glove is inside of it a amount of marijuana undetermined. That's for indictment number 23 SC 187946. Your Honor, also indictment number 23 SC 187636. Mr. Anthony, on June the 9th, 2022, Mr. Anthony was observed on 20 Broad Street, Southwest Atlanta in Fulton County. At that time, the officer observed him rolling a blunt. They stopped him and arrested him. And then upon arresting him and searching his bag, they found the meth inside the bag. Both of these were in Fulton County, Your Honor.
And so your recommendation is for both of the indictments, 10 years to serve, 1 commuted time served?
On indictment number 23 SC 187946, the maximum is 5 years, so it'd be 5 years probation, Your Honor.
All right, and that's to be served concurrently.
Yes, Your Honor.
Okay, Mr. Clark.
Yes, Your Honor. The only other thing we would request, and we would ask the court accept the negotiated agreement, is to set Mr. Nichols a behavior incentive date of 3 years out. What I can let the court know is he's also on probation for a further 6 years in a case out of, I believe, what judge was it?
Bedford.
Yeah. On a additional felony case, Your Honor. And so we would ask the court to, I guess, give him the opportunity, if he is able to get out and do what he's supposed to do to have these terminated and not have his probation further extended beyond what it already is. What I'd note to the court as well is he's been in touch with his probation officer. His family lives in Florida. That's where he would like to return to. I've talked with him obviously about interstate compact and the process he has to go through there. And he's been talking with his probation officer while he's been in custody to be proactive about that. Other than that, Your Honor, Mr. Nichols has some mental health issues. I think that's at the root of using the marijuana. Obviously, one case has a possession of methamphetamine with intent to distribute, but marijuana was involved there. He has obviously, since he's been in custody, been placed on some mental health medication. And in my conversations with him, it seems to be having a good effect. So we would ask the court, obviously, he's going to be taking a substance abuse evaluation, going to be drug tested as part of probation. We would ask the court accept this recommendation and sentence it.
Mr. Bridges, your thoughts on the 3-year incentive date?
I have no objection, Your Honor, but we would add that Mr. Anthony must maintain and continue to take all his medication as prescribed by the doctors.
And no objection to that.
Now it's Anthony Nichols, right?
Yes, sir.
Okay, so Mr. Nichols, do you understand the nature of the charges against you?
Yes, sir.
You've just heard ADA Bridges explain all the rights you give up learning this guilty plea. Is it your wish to give up these rights and have this court accept your plea of guilty?
Yes, sir.
Do you understand the court is not bound by the recommendation of the plea agreement? I can sentence you as I deem appropriate.
Yes, sir.
Are you pleading guilty because you are in fact guilty?
Yes, sir.
Mr. Clark, you satisfied that your client is competent, understanding that the plea is voluntary and there's sufficient factual basis for entering the plea?
I am.
I find there is sufficient factual basis for the charges. I also find your plea of guilty to be knowingly, voluntarily, and intelligently entered. I'll accept your guilty plea and sentence you as follows, which is the recommended sentence. And so on 23 SC 186636, you are to sentence 10 to serve 1, commuted to time served. You're to have a drug and alcohol evaluation and follow any of the recommendations. You are to have no drugs without a prescription, no alcohol, and to remain gainfully employed once you're out. And I will agree to the behavioral incentive date of 3 years, but as has been stated twice now, one of the conditions is that you remain compliant with any recommendations from your drug evaluation, and you're to have no drugs or alcohol. On the 23 SC 187946, it'll be 5 years probation to be served concurrent to the 23 SC 187636 case. Is there anything else?
No, sir.
Nothing further, Your Honor.
Okay, you're excused. Oh, does Ms. Cullors need to? Ms. Cullors is on Zoom.
I am right here. Did he leave?
Mr. Nichols, no, he's still here. Why don't you come up? The probation is on Zoom and she wants to give you some instructions. Okay, Mr. Nichols?
Okay, Mr. Nichols, I do understand that you have been in contact with your officer. Would that be Officer Benton?
No, ma'am.
Okay, well, your present officer is Officer Benton, and that is who I would need for you to report to 48 hours. Well, actually, you're wanting to, I understand that you're wanting to go to Florida with your family.
Yes, ma'am.
Okay, I will need for you to report, because I don't know if you'll be able to do it tomorrow before noon, but I would need for you to report to your officer, Officer Benton, and she'll give you further instructions as to how you can proceed with your ICOTS. I will tell you that it is a $100 fee. And if Mr. Clark could take down Officer Benton's number, I'd be more than happy to give it to you so that you can have it and she can, you can talk to her about your transfer to Florida, okay?
Okay.
I'll take it down, yeah.
It is area code 470-936-2909. And just contact her within 48 hours of your release. And just let her know that you're wanting to move to Florida and she will be able to facilitate that for you, okay?
Yes, ma'am. Thank you.
Thank you. Have a good day.
Okay.
Does he have a hold for the other probation?
No, he took care of his probation violation already. Yeah. Yes.
Yes, ma'am.
All right, so Mr. Clark, just quick housekeeping matters, because I'm going to take about a 20-minute break, but your motion for speedy trial in the state, that should not be very long, correct? I mean,
I don't see that being more than 15 to 20 minutes of argument max. I don't know.
That's correct.
all right, so let's take a 20-minute break. My plan is to take you up first then, and we'll do the plea and arraignment paperwork. Has that already been filled out?
It has not, Your Honor, but Mr. Brown was not up, so when he gets up, I'll go back and sign.
Okay. All right, we'll see you in a little bit.
Okay.
Agreement and conditions for Mr. Anthony, for Mr. Nichols, for both cases.
Yes, I will.
Thank you so much. Huh? I'm saying. Okay.
It was Brown.
Courtney
and then-
Brown, and then,
That other guy that kept asking.
Little.
Yeah, Little.
Mr. Little.
Yeah, Miss Ingram should be.
She's not in custody.
Yeah, no, someone said she should be
Oh,
out there.
sorry. I was gonna say unless something changed that I don't know about.
What happened to position 14, Callie, Callie Barnes?
That's the young lady who, she had to, she had to find out, if she was, hold on, let me.
Oh, yeah, that's the one that
Hold on,
may have Bruce Harvey, may not.
right.
Yeah,
So
Okay.
Turn the TV off. Stop, Billy.
We're saving the 418 for last.
And Jackson then on for
I thought there might be one in there. Well, we'll see, you know. We'll see. Yep. Yeah, give me that when you're done with it. What? She left us. Where'd Mr. Clark go? Oh. I think it's gonna staple last time. Doesn't staple. I can staple. Well, I was planning on it, but it seemed like there's nothing I can do now anyway, because well, no, I thought we'd move through Brown more quickly. What, did you,
Yeah, I think because Mr. Clark was ill last week, he hadn't had a chance to
Oh.
speak with his clients, so he's-
is he doing the plea and arraignment? I mean, is he doing the indictment waiver and all that with him now?
I'm not sure. I just know that he
Okay.
indicated he hadn't had a chance to speak
All
with
right.
them. I think there was an updated offer maybe.
Okay. The updated offer? I mean, I saw it online. Yeah, because we might have to clear the deck on this. Yeah, I'm on it. The battery went dead on this, and I can just write notes by hand.
Yeah, I believe he went back. It was at least my understanding, and now he's not here, so. Maybe I shouldn't assume, huh?
Yeah, in my office, in that judicial bag I have that has the Superior Court logo on it, bring out the whole bag if you don't mind. Thanks. All right, you ready to bring out Mr. Brown?
Yeah, sure.
Okay, go ahead and bring out Mr. Brown. She went to go get something for me. Thank you. Right here, sir. Okay, this is 23 SC 187734, Courtney Jamal Brown, who is present in the courtroom with his attorney, Mr. Clark, and we have Mr. Miller representing the state. Go ahead, Mr. Clark.
Your Honor, we are here for arraignment as well. Mr. Brown would waive formal arraignment and enter a not guilty plea on this indictment. He had obviously done so on the prior indictment as well. As far as anything else, I guess I would defer to Mr. Miller's announcement on anything regarding speedy trial at this point. I think we can have a conversation about that.
Do you have the paperwork for the plea and arraignment?
I do not, Your Honor.
This. All right, well, we can get to that. This, I don't have it. What paper? Oh. I think so. Right here, this Jackson Deno paperwork. Nope. All right, you can print that up. And so why don't we let I have your statutory demand for the speedy trial, straightforward enough. So we'll go ahead and let Mr. Miller argue for the state.
Yes, sir. Thank you. The state would ask that the court not require the state to try Mr. Brown during this term or the next, as indicated in the demand for speedy trial. The state would point the court to a case that is State v. Summich. That citation is 266 Georgia Appeals 630. Your Honor, in that case, the defendant was charged with counts of child molestation and cruelty to children. Following a jury trial in which he was found guilty, the Court of Appeals reversed and remanded that case. And on remand, the defendant filed a motion for acquittal based on the state's failure to timely try him.
Wait, can you give me that case site one more time?
Absolutely, Your Honor. 266 Georgia Appeals 630. And I have a copy for the court as well, if I may.
Well, that'd be great. Yeah, if you could just bring that up. Thank you, Mr. Miller.
So, Your Honor, in that case, State v. Summich, Mr. Summich was charged with 2 counts of child molestation. He then was indicted. He was re-indicted 11 months later. And on the re-indictment, 2 other additional charges were added. It was at that time that his defense counsel then filed a motion for a demand for speedy trial. And he was asserting that due to the failure of the state to try him, due to that demand, that the whole case should be dismissed or acquitted. Your Honor, the court in this case had held, Your Honor, that because the defendant failed to file a demand for speedy trial under the original indictment, he waived his right for a demand for a speedy trial on the new indictment as to the charges that are identical on each indictment. In the case that is before this court, Your Honor, Mr. Brown was indicted, Your Honor, back in 2021 for several counts, 10 counts to be exact. However, this case was re-indicted early this year. On the re-indictment, Your Honor, only 2 co-defendants were added. As to the charges for Mr. Brown, the charges are actually identical. No charges were added or taken away from both indictments. And the state would ask, Your Honor, to abide by the ruling in State v. Summich and move forward without requiring the state to try Mr. Brown according to the speedy trial demand filed by defense.
So the case is re-indicted. Are you saying they're identical charges of the re-indictment or they're added charges?
They are identical charges on both indictments, Your Honor, as to Mr. Brown.
And a re-indictment tolls explain that to me again.
Yes, Your Honor. So based on the reasoning in State v. Summich, because Summich's attorney failed to file a demand for speedy trial under the old indictment, he waived his right for a demand for a speedy trial on the new indictment as to the charges that are identical on both indictments. Before this court, Mr. Brown's case, Your Honor, he only had 10 counts on the old indictment, which are the exact charges on the new indictment. The only difference is that the state only added 2 co-defendants, but the charges to Mr. Brown are exactly the same on both indictments. There was no demand for a speedy trial filed for Mr. Brown on the 21 SC case, the old indictment, nor was there a motion to file to incorporate the previous filings under the 21 SC case under the new indictment also, Your Honor. Because he failed to file a demand for a speedy trial under the old indictment, we believe, Your Honor, that Mr. Brown waived his right for demand for a speedy trial under the new indictment as to the charges that are identical on both indictments.
Okay. All right, Mr. Clark.
Yes, Your Honor. And then just responding to that, the case the state cites, which is some State versus Summage, essentially what the logic that the court is using there is following a line of cases it cites from Clark versus the state, which was 271 Georgia 519. That line of cases, Clark, is essentially the final line in this question of whether in traffic court and state court, whether when a uniform traffic citation is taken out, whether a speedy could be subsequently filed on a written drawn up accusation. And what the courts had said is because that accusation is essentially superfluous at that point, that no, that the rule that the state is citing, that the original speedy would have to be attached to the uniform traffic citation, that's the rationale behind that. What I can state is I don't think the re-indictment here is merely superfluous. Yes, the charges are the exact same. However, what has been added are 2 additional co-defendants. What I can state as well is that these 2 co-defendants, I guess taken in turn, it's not superfluous because obviously that changes the complexion of the case. Now, instead of Mr. Brown being tried alone, there are 2 separate individuals that will be tried alongside Mr. Brown. That gives the state essentially leverage to speak with those individuals, potentially work out plea deals to arrange their testimony against Mr. Brown. So it changes the complexion of the case in a way that simply re-indicting to change verbiage or to add a count would not. Additionally, Your Honor, I have issue with the state as far as the way this case is taken, has proceeded, because the state has known about these individuals that were added, and I've stated that before to the court. This case was re-indicted on the eve of trial back in May. These individuals, based on the discovery that has been provided to me, were known by the state as early as December of 2020. Some of them were on scene when the initial response was had. So my contention and what I think the court has to be able to take into consideration is to say that this was indicted to add individuals, in my perspective, that this was done at a point where I can't assume what's behind the state's motivation, but the fact that they knew about these individuals for the entirety of this case, and when this case was set on a trial calendar, the state wanted to ask for it to be specially set and then subsequently re-indicted it to add them, coming into court at the final plea announcing that they were re-indicting the case, it certainly appears to me that this was done potentially for delay. And so I think that based on the logic of this case that the state cites, this isn't mere surplus, this isn't superfluous, this isn't correcting any sort of language or verbiage or anything like that. This has fundamentally changed the nature of the state's case against Mr. Brown. And I don't think that I do think speedy trial rights should be allowed to attach. There's nothing in the plain language of the statute that would prohibit this. It is solely this court case from 2004 that would extend that principle that was otherwise confined to the realm of uniform traffic citations to indictments. And so, Your Honor, I would contend that the speedy should be allowed to go forward as set forth in the law, that this should be tried within the requisite time period. Or else that we could file a motion to discharge at that point. And I think the only other thing I'd note for the record just is the amount of time that Mr. Brown has been in custody since February of 2021 when he was brought to Georgia on this. And so we're in the context of the indictment was made over 2 years after his arrest, the re-indictment. I apologize. And so I think we're in a position now where one of the co-defendants still has not been picked up. One of them is in federal custody. The state maintains its intention to try these jointly. That's been the announcement at previous calendars. So this thing just needs to be tried. And I think the court has to take all of those into account.
I mean, I'm trying to separate my mind. What's a legal argument on the statutory which is more black and white, and what's more of a constitutional speedy analysis that you're making. Mr. Miller, what's your, do you have a response?
So, Your Honor, I do understand that Mr. Brown has been in custody for over 900 days. The state did file a motion to have this case spatially set, and the state would ask that that be done. We would ask that if possible, the matter be set for sometime in December. We do have several out-of-state witnesses. I do believe that that would provide more of a middle ground between defense and state. Defense wanting the matter to be tried in the state also, and not wanting any further delay. And so I would ask if possible, this matter be especially set sometime in December. I do understand that there's one defendant whose matter should be placed on judicial hold status. There's another defendant that is in federal custody. I do believe that a December date will provide each counsel sufficient time to review discovery, consider state's offer, and determine whether or not they're ready for trial or not. And so I would ask that be done now.
So in your perfect world, I would rule against his statutory demand for speedy trial, citing State versus Summage as the primary case, and especially set this for December. And what, Christmas Eve or?
But just sometime before Christmas. Before or after is fine, Your Honor. But what I want to do is, again, just give my out-of-state witnesses sufficient notice. That's the only reason why I asked for late December.
And so, and you especially set it in December. And if you can't find that one defendant, too bad, we sever him out.
And Your Honor, if December, from my calculation, is within the period of a statutory speedy.
Is it? Because you filed it, I have it in front. I thought you filed it on 8/31.
I did.
And so that was the last term, right? Am I doing my math right? And so this term is September, October.
I think there could be a question as far as whether jurors were impaneled when I filed it.
Okay.
Which may extend it to the January. So I guess my suggestion was, in my view, that could be within the original term of the speedy, to not make a ruling unless we don't go to trial at that term. Because I think that would be, I think the state is being proactive about making sure that they don't prepare if it's not necessary, but if they're willing to agree to a December trial term, that would be fine with us. And then I think the issue would be if it's not reached in December and I file a motion to dismiss, then it may be more ripe then.
All right, I mean, all things being equal, I'd rather moot your demand and have the trial in December.
No, that's the state's request. I mean, based on our calculations, it was filed August 31st, and so we did count that term along with this term that ends November 6th. So we did consider that. I was unable to come across any information to determine whether or not jurors were paneled that late August, early September, which is why we stand in opposition to the demands.
Do you have anything set for that December 4th calendar? That's specially set, right? Oh, yeah. That's backup. And then what's the civil trial week? Is that with me or is that a senior judge that's doing that? What about the November 20th calendar? It's going to be a 2-week calendar, but is there anything specially set? Would you be able to be ready by November 20th?
I do not believe so, Your Honor. To my understanding, we have a map for this court proceeding, Jerry. It is on 6, so I believe it's on that matter.
Well, I mean, the speedy is the speedy. It's just a question of whether we follow Mr. Clark's logic that we don't know whether there was a jury impaneled on the 31st. I bet there was. I mean, all right. Well, there's no reason to make anybody wait right now. I'll tell you what, we will come up with a trial date and I'm going to have to rule on this motion, but perhaps the two councils can get together as well on this, if they can provide mutual agreement on this statutory demand for speedy trial, and maybe I won't have to dig too deep into it.
Yes, Your Honor.
Okay.
May approach with the.
Yeah. All right, Mr. Brown, you're pleading not guilty today?
Yes, sir.
And that's your signature on this indictment right under where it's checked not guilty?
Yes, sir.
Okay. All right, you're excused.
Thank you, Your Honor.
And we'll come up with a date. We're gonna have to look at that counter because this may take priority over that. Now, why, Mr. Miller, why did you said you have your co-counsel on a case November 6th, but why does that preclude you from November 20th?
Well, I will be sitting with her on that trial as well, so I'll be. I have.
Yeah.
Thursday, and I'll,
Yeah. Okay. All right. Well, we may be running up at the end of October, so maybe end of November would be better, but all right. Okay. All right, Mr. Clark, you are excused. You're excused, Mr. Miller.
You want to come up and sit with your client, Ms. Ingram?
Yeah, I'm gonna move my stuff. Spot I can.
Ms. Jones is gonna sit right here. Mr. Little will be right here. Right, I'll come. Look at her, she'll wait, I can for her to sit down. We'll sit right here. How are you?
Hey, how are you? Good to see you.
I think you're ready for my client.
Yeah,
Okay,
we were most definitely ready.
so make sure.
Okay, so this is 23 SC 187794. We have Quasi Little, who is joined by his attorney, Ms. Jones. We have Sharice Ingram, who's joined by her attorney, Mr. Tucker. And we have Ms. Beza and Mr. Carlson representing the state. Why don't we take up the 418 motion first? Who's going to be arguing that?
I'm going to be offering the facts of the cases and Mr. Carlson will do the edit.
Okay. All right, we'll go ahead.
Your Honor, in regards to the 418 motion, that was a courtesy copy was emailed on September 8th of 2020. Not September 8th, I'm sorry. One moment, Your Honor. A courtesy copy was emailed. Yes, September 8th of 2023 this year. The state seeks to introduce two acts of criminal gang activity, and I'm going to go through the factual allegations of both. And both police reports that relate to both acts were also served with this motion. So the first one, and in full deference to the court, was dismissed on October 26th of 2022. The case number was 19 CP 180932. It was actually dismissed, giving the reasons of length of time and no forensic interviews were completed. But in that case, the defendant was arrested on cruelty to children in the first degree, aggravated assault strangulation, and 2 counts of aggravated assault and simple battery. The date of offense was December 6th of 2018, and the date of arrest was January 17th of 2019. In that case, and the allegations in that case were that on December 6th of 2018, Officer Ward responded to 973 DeSoto Street in Fulton County in response to an assault call. Upon arrival, Officer Ward met with the victim's Precious Allen, who is believed to be the sister of the defendant, and Jasmine Crumbly, her friend. Precious told Officer Ward that the defendant Little resides at home with her and her dad. On the night of the incident, Precious invited her friend Jasmine over to spend the night. Precious and Jasmine were in the kitchen making dinner. Defendant Little entered the kitchen and started harassing them and further demanding that Jasmine go home. Jasmine refused. Defendant Little then pushed and held Precious against the wall by her face and punched her in the mouth. He then placed his hands around Jasmine's neck until she blacked out, pursuant to the police report. The defendant Little then swung a broom at both victims and fled the scene. The second act of criminal gang activity that the state is seeking to introduce as this type of 418 evidence is an aggravated assault strangulation case. In this case, the defendant was convicted on July 3rd of 2019 under indictment 19 SC 168753. The date of the offense was April 16th of 2019, and the date of arrest was also April 16th of 2019. Now, in this case, on April 16th of 2019 at approximately 2:30 p.m., Officer Johnson responded to 10 Pine Canyon Drive here in Fulton County. Upon arrival, Officer Johnson spoke with the victim in this case, Antonia Weaver, Antoiwana, who stated that defendant Little was upset because she ended her relationship with him. Pursuant to the police report, her husband had gotten out of jail, and so then she ended her relationship with defendant Little. The defendant Little was upset and placed his hands around her neck and squeezed until she could not breathe. Defendant Little repeatedly stated to her, "Me or death." Ms. Weaver told the police that Ms. Weaver, had faint red visible markings on her neck. She texted her daughter to contact the police. She stated in the text message that Nuce, Nukce, that's what she spelled her text as, Nuce, which is what she calls her daughter, nickname, called the police. Quay's trying to kill me. So those 2 acts of criminal gang activity is the state's argument we would like to be introduced in our trial as 418 evidence. I'm now going to turn it over to my co-counsel, Mr. Mike Carlson, to argue the law on those types of evidence.
Okay.
Afternoon, Your Honor. Again, Mike Carlson on behalf of the state on this issue. We're looking at Official Code of Georgia 24-4-418. And what that statute is, Your Honor, is a Georgia-specific evidence code provision that is patterned after the federal rules and our state rules with regard to acts of sexual misconduct. And the foundational considerations here are one, is the defendant in question charged with a violation of Georgia Street Gang Terrorism Prevention Act? That's true in this case. The defendant is in fact charged under 1615-4. So then the next question is the uncharged misconduct in question, the other act or acts, do those represent offenses that constitute criminal gang activity under OCGA 1615-3, the definitional section? Those include anything that would constitute a crime of violence. Then our other considerations, which are not really in play here. Is there sufficient notice? We are well in advance of 10 days before trial here, Judge. And then lastly, there's a Rule 403 consideration, but then that is naturally less a factor pre-trial where we are now, because of course the courts frown on pre-trial exclusion of relevant evidence under Rule 403, too much of a vacuum. So these acts here are clearly acts of violence. They fall within the confines of and definitions of criminal gang activity. The defendant in question has been charged with violations of 1615-4. So this statute says those acts are presumptively admissible. There still is a 403 component to that. So what we're asking is, of course, for conditional admission of this evidence. It satisfies 403 at this point, recognizing the court might make a 403 determination at a later point in time in the case. So Judge, this is a presumptive admissibility statute. And again, we're asking for this to be admitted for all relevant purposes. That includes criminal propensity. Those are the terms of the statute. We ask that our motion be granted.
In 1 minute. All right, go ahead, Ms. Jones.
Thank you, Your Honor. I see there's some people on Zoom. Your Honor, in Randolph v. State 334, Georgia Appellate 475, the court did indicate that it's simply not enough to show that the defendant or other gang members committed a criminal act. Rather, there must be some nexus between the act and the intent of further gang activity. Here, the state is not proffering anything in regard to how some domestic violence incidents relate or have furthered some sort of gang activity on the part of Mr. Little.
What's that site? What's that site again?
That is going to be Randolph v. State 334, Georgia Appellate 475. And we also have Overstreet v. State 312, Georgia 565-21, which also indicates to satisfy the fourth and final element of violations of the Gang Act, the state has to prove that the commission of the predicate acts was intended to further the interests of a gang. To do so, the state has to show some nexus between the acts and an intent to further street gang activity. Your Honor, there's been no proffer in regard to what specific gang he's been in or is in, what activity related to the domestic violence that he is furthering in the alleged felony murder and or murder charge that Mr. Little is currently facing. There has to be a nexus. There has to be some sort of interest, like it has to be some sort of nexus. And to date, I have not received any type of nexus in terms of how a domestic violence incident that occurred in 2019 is relevant to an indictment in 2022, Your Honor. And for those reasons, we would object to this coming in as gang activity, Your Honor, because again, the state hasn't shown that there has been a nexus. And we would also, if you are inclined to think that there is some sort of nexus without that additional evidence or testimony, we would believe that it would be more prejudicial than probative, but I can let the state speak to what they believe their nexus is.
May I be heard, Your Honor?
Yes, you may be heard.
That argument that opposing counsel just provided us with resulted in one of your colleagues getting reversed out of this circuit. I'm going to cite that case, Your Honor, and I'll say I'm one of the people on that brief. State versus McKinney, 366, Georgia Appeals 251. State versus McKinney, 366, Georgia Appeals 251. That's a November 9th, 2022 case out of Fulton County. It is cert pending, but the deviation from the plain language of Rule 418 that opposing counsel is asking the court to engage in was specifically repudiated by a unanimous Court of Appeals, authored by Judge Brown, joined by Judge Barnes, and Judge Hodges. The conflation that's going on here, Your Honor, is between the offense of 1615-4A and the definition under 1615-3. 1615-4A has certain requirements in order to convict a defendant of one of the subsections of the Street Gang Act. And one of those requirements is that the state demonstrate the defendant participated in the criminal street gang through the commission of the underlying offense. That's commonly referred to as the nexus requirement. That ultimately comes from a 2009 case out of DeKalb County. A unanimous Supreme Court upheld the constitutionality of the gang statute in a case that I argued in front of our Supreme Court and was authored by the decision authored by Justice Carlin. What McKinney did was take this specific argument and say the evidence code provision is drafted in a different way. The 1615-4 requirement is when this applies, just like 413 or 414 apply in the case of sexual offense prosecution. But the definition of what sort of offense can come in is strictly restricted to the definitions under 1615-3. And that is it a crime involving violence? Doesn't have to have been charged under the racketeering laws, doesn't have to have been charged under the Street Gang Act, and definitely doesn't have to have resulted in a conviction in either one. And Judge, I will say we drafted Rule 418 very cautiously, specifically to deal with these arguments in advance. And again, McKinney speaks for itself, Your Honor, but again, excluding the gang evidence pre-trial that qualified as 418 evidence, exactly how the state is arguing it now, excluding it pre-trial resulted in reversal. We're asking you to apply McKinney as it stands now, recognizing, of course, cert is pending.
1 minute here is so under 1615-3, which one are you citing? Or which definition? I'm just perusing them now.
Well, A has the list of offenses that qualify, Your Honor, so I don't want to accidentally give you from memory which one it is. Then B is actually an evidence code provision that's housed in 3. So subsection J, as in Jerome, Your Honor, any offense involving violence.
So it's your contention that there doesn't need to be any nexus whatsoever. I mean, if there's sufficient proof that or sufficient evidence provided that you're in a gang and you commit any violence whatsoever, it comes in.
Subject to us being able to prove at trial that it occurred, but yes, Judge, there's no nexus requirement housed in the evidence provision. And that's not only, well, certainly the Court of Appeals joined in that contention.
What about Ms. Jones's other point that there's been no evidence presented regarding what street gang he's in or?
Well, that's a proof issue at trial, Judge. The statute requires, has he been charged with a 1615-4 offense? And he has been charged with, I believe, 3 subsections in this indictment. Then if the other act qualifies under 1615-3, it shall be admitted. We recognize, and it was testified to in this effect, if I remember correctly, in the General Assembly, 403 does apply. But again, he's got counts 1, 2, and 3 of this indictment bring us within the ambit of 418.
Okay, Ms. Jones. I'll give you another bite at it if you want it.
Your Honor, I am looking at State v. McKinney, and they do talk a little bit about Overstreet, and Overstreet is a Supreme Court decision. It's not an appellate decision. And the Supreme Court has made very clear that to be convicted or have a violation, the commission of the predicate acts was intended to further the interests of the gang. I think we even have to step back one step in regard to the motion of the state. They haven't alleged what specific gang he is supposed to be a part of. That's not in the indictment, or it wasn't in the old indictment. I think it's in the new indictment, but they haven't provided any proof or any showing that this is some sort of gang activity, Your Honor. And there certainly hasn't been a proffer of a nexus as to how a domestic violence incident involving an ex-girlfriend
Well, yeah, but
somehow furthers the interests of gang activity.
Well, I agree with that, but I believe Mr. Carlson's position is you don't have to have the nexus.
And with all due respect, Your Honor, I do believe that Overstreet v. State is still controlling. That maybe McKinney is looking at some issues in regard to the nexus, and they do talk about the statute, and that it doesn't necessarily refer to the nexus. But again, this Overstreet v. State is a 2021 decision by the Supreme Court of Georgia.
Yeah.
And the appellate court certainly can't overrule a Supreme Court decision.
Okay. Anything else? Mr. Carlson?
We'll stand on our.
All right. That concludes the 418 aspect of it.
As to 418, Your Honor, yes, because the Overstreet deals with whether or not a conviction under 1615-4 was supported by the facts. Overstreet does not deal with admissibility of evidence under 418. There's a mention in there, if I remember the decision correctly, that evidence was admitted under 418. But McKinney is the seminal case in terms of the application of the rule.
Okay.
And again, it is very clear. And opposing counsel is not moved, I would point out for the record, to demur any counts of this indictment on the belief that somehow a gang has to be mentioned. But of course, a criminal street gang is mentioned in the indictment. But we've heard a lot, but we haven't seen anything in writing to substantiate any of those positions.
Okay. All right. Well, I'm going to take that under advisement.
And just to make a note of point, given the state indicating that we haven't filed any demurs, I have been requesting what specific evidence they had in terms of gang activity for my clients since this case was re-indicted back in April, which stopped the trial that was going to go forward. On September 29th of this year, Your Honor, I finally got a 10-page I guess slideshow, for lack of a better word, that was printed out that alleges the ties to my clients. So for me to demur, I actually have to have that evidence. I have to be able to figure out specifically what arguments I need to make. And when the state won't give it to me, I can't make those arguments. And I just received that information on the 29th of September on a Friday after 5.
All right. Well, Mr. Carlson, do you want to respond to that since it's your motion?
Well, Judge, the charging instrument in this case, if there was some technical problem with it, opposing counsel certainly could have made a motion along those lines. That's been there prior to September 29th. Opposing counsel has had this information from my co-counsel in terms of not only gang experts, but other gang evidence here. We do have an open file policy. It was a notice filed to that effect, Your Honor. And that satisfies the state's discovery obligations in and of itself. But we're getting far afield, Judge, of whether or not crimes of violence committed by a street gang act violation charged defendant are admissible under Rule 418 for all relevant purposes. The answer to that is yes. We respectfully request that our motion be granted. And I would say, apparently I've been corrected, the resumes of the proffered experts have been out since May of 2023 to opposing counsel. I'm advised, and I guess May from investigator Lyda, that's LYDA. And it's September from Tealer, TEALER. Whether or not opposing counsel has attempted to contact those people, their investigators have, I suppose we'll see later this year.
Well, I mean, I think that concludes the 418 aspect, right?
Yes, Judge.
Okay, you'd mentioned C later in this hearing and just wanted to make sure that we were.
Understood. We'll stand on 418.
Okay.
The text of the statute.
Okay, all right, okay. All right, and then you have your reverse Jackson Deno. Thank you.
Order, Your Honor would like to do that, but since you mentioned the adverse Jackson Deno hearing, the state did file a motion for the court to rule on the voluntariness of Little's statements and Ingram's statements to Detective Sluss. The state is asking for a preliminary ruling on the voluntariness pursuant to Colton v. State, 292 Georgia 509 518. It's a 2013 case. If the defense consents that the statements were voluntary, then there's no need for a hearing, but we do have a witness here to testify to both statements.
All right, Mr. Tucker and Ms. Jones.
At this time, I wouldn't have an objection. I don't think, I don't think the voluntariness is going to be in question. The word Miranda rights were read. Questions were answered. So there's no objection here from our side.
Okay. Ms. Jones.
We would request a Jackson v. Deno hearing.
Okay. You want to go forward with the, as you like to call the reverse Jackson Deno hearing?
Yes, Your Honor. The state calls Detective Sluss. In regards to publishing the statement, would you like us to email it afterwards or play it in order to see?
You know, what I prefer is why don't you email it, and if there are particular areas that you think ought to focus on, you can cite those areas in your argument.
I will, Your Honor.
So what we got? Detective Ronald Sluss, RONALD SLUSS. Good afternoon, ma'am.
Where are you currently employed?
With the Atlanta Police Department.
In what capacity?
I'm a detective
What unit?
with the Homeland Security Unit.
How long have you worked for Homeland Security?
A little over a year.
Where were you assigned prior?
To the Homicide Unit.
What were some of your duties and responsibilities in the homicide unit?
Investigated murders.
How long total were you in the homicide unit approximately?
A little over 5 years.
And how long total with APD?
Coming on my 17th anniversary.
Are you post-certified?
I am, ma'am.
For training?
Yes, ma'am.
Were you post-certified in the year 2022?
Yes, ma'am.
I want to direct your attention to January 24th of 2022. Were you working that day?
Yes, ma'am.
Did there come a point in time where you became involved in an investigation of an alleged homicide that happened on Anderson Avenue?
Yes, ma'am.
What county?
That's Fulton County.
What was your position in this case?
I was a lead detective.
As part of being the lead detective, did you interview a person by the name of Crazy Little on January 25th of 2022?
Yes, ma'am.
The person that you interviewed on January 25th of 2022 named Crazy Little, do you see him in the courtroom today?
Can you remove your mask?
And may you point him out and identify an article of clothing he is wearing?
Yes, he's in between counsel and he's wearing an orange jumpsuit.
Where did you interview?
At the Atlanta Police Headquarters.
Was the interview recorded?
Yes, ma'am, it was.
I'm going to hand you State's Exhibit 1, showing it to defense first. Do you recognize State's Exhibit 1?
Yes, ma'am.
What do you recognize it to be?
This is a copy of the interview that I did with Mr. Little,
And how do you know that that interview was on this actual CD?
because I signed the CD after watching it.
And is it a fair and accurate recording of your interview with defendant Little?
Yes, ma'am.
And at this time, the state moves State Exhibit 1 into evidence.
Ms. Jones,
No objection.
so moved.
Prior to speaking with the defendant Little about this case or in that interview on Exhibit 1, did you read him Miranda warnings?
Yes, ma'am.
And did he waive those Miranda warnings?
He did.
And during your entire interview with defendant Little, did you force him to speak with you?
No, ma'am.
Did you threaten him in any way?
No, ma'am.
Did you coerce him to speak with you?
No, ma'am.
Did you promise the defendant Little anything in return to making a statement to you?
No, ma'am.
Did you offer defendant Little the slightest hope of benefit?
No, ma'am.
The defendant Little appeared to understand English.
Yes, ma'am, he did.
Did he appear coherent?
Yes, ma'am, he did.
Do you have any reason to believe that defendant Little did not understand your questions?
No, ma'am.
Did defendant Little have an opportunity to eat something during your interview?
Yes, ma'am. I bought him pizza.
Did defendant Little have an opportunity to drink anything during your interview?
Yes, ma'am.
And was that a soda?
Yes, ma'am, it was.
Now, during the time that you spent with the defendant Little in the interview room, did he ask you to go, can he grab a smoke?
Yes, ma'am.
And did you allow defendant Little to grab a smoke outside?
Yes, ma'am.
Now, besides what's in State's Exhibit 1 in regards to defendant Little's interview, did you have any further conversations with him about this case?
Outside while he was smoking, but that's about it.
No further questions for this one.
Okay, Ms. Jones,
Thank you. It's Sergeant Slutz, correct?
Nah, detective.
Detective.
how do you spell that again?
S is in Sam, L is in Lincoln, U is in Uncle, S is in Sam, S is in Sam.
All right, that's how it sounds.
Yes, sir. Plus, but with an S, that's all.
Now, initially, when Mr. Little was brought in for interrogation, he had a probation warrant, correct?
I believe so, yes, ma'am.
Okay, and in fact, when you first spoke with him before reading his Miranda warnings, he was concerned about that probation warrant.
I don't know whether he's concerned or not, but I know that he mentioned it.
He wanted to go home, correct?
Yes, everybody always wants to go home, ma'am.
Okay, and he was worried that that probation hold was going to hold him after he spoke to you.
I don't know. I'll let him explain that.
You don't recall that in the conversation?
No, ma'am. Again, I don't. It's been a couple of years.
Okay, and do you recall prior to having Miranda that Mr. Little asked you after we talked, can I go home?
I don't
And
recall.
you indicated, well, we've got this warrant for your quote unquote probation thing. Do you recall that?
No, ma'am.
Okay, if it's in, you indicated, did you watch that prior to coming here today?
No, ma'am.
Okay, so when you testified that that's a fair and accurate representation of that interview, you don't know.
Well, no, I watched it back when was it January? I believe I signed this back in January. I watched it. I signed it for the council.
Okay, so you watched it back in January, but you haven't watched it since?
No, ma'am.
Okay, and you don't recall anything about probation being mentioned?
Well, no, we've already spoken about that.
Okay, but, and he was concerned about his probation warrant,
Yes,
correct?
ma'am. That's what you said.
Okay, and when he talked about to you, you also indicated prior to reading his Miranda warnings, you were also talking about people were talking, neighbors were talking, and you wanted to find some peace for this baby's child, correct?
Again, I can refer you to the recording, ma'am.
Okay, so if there was a transcript that was provided in regard to that conversation, could that have been said?
I would imagine. I don't know. I didn't make a transcription.
It'll be in the tape,
It'll be in the
correct?
tape. Yes, ma'am. Everything's right there and recorded.
And you also indicated you needed to know before Miranda rights were read, whether or not this was intentional or accidental, correct?
Again, I'll refer you to the recording, ma'am.
Okay. And you also indicated you bought him a piece of pizza, correct, or pizza?
Yes, ma'am.
Do you recall Mr. Little actually eating any of that pizza?
I don't recall.
In fact, he didn't eat any of that pizza, correct?
Oh, I have no idea. I don't recall. I know I ate pizza. I was starving.
I recall you eating pizza, but that tape isn't going to show him eating pizza, correct?
No, but it was,
Asked and answered.
Sustained.
You also indicated to him that he had the right to talk to you or not talk to you, correct?
again, I'll refer you to the recording.
Okay. And in fact, he was very concerned about the fact that if he didn't talk to you, it was going to look like he was hiding something. Do you
Again,
recall that?
I'm gonna refer you to the recording now.
Okay. And he was also very concerned about going to jail, correct?
Again, I'll refer you to the recording.
Okay. And that was all done pre-Miranda, correct?
Again, I'll refer you to the recording.
Okay. And again, he reiterates that he wants to go home and he's not sure if he can go home if he doesn't talk to you. Do you recall that?
Again,
Your Honor,
Okay.
Exhibit 1 speaks for itself. If we want to play the entire recording, we can in court today, but Exhibit 1 speaks for itself. The best evidence is that of the recording, not of Detective Sless's memory of what was said on the recording that's in evidence.
Ms. Jones?
I have a right to try to refresh his memory and we can take his answer as it is. Otherwise, I could go back and replay it to refresh his memory. But I have an absolute right to talk about whether or not what he remembers specifically on that record. And if I so choose, go back and impeach. He's indicating he doesn't recall. He also says that it's going to be in that tape and we are taking that as you are going to be watching it.
Your Honor, what she's doing is not refreshing his recollection. What would be refreshing his recollection is if Ms. Jones handed him the actual transcript, said refer to page 5 and read lines 5 through 10. Is your memory refreshed? That would be refreshing. his
Well,
recollection.
Ms. Beja, I'm going to overrule only because, I mean, we're asking me to be a gatekeeper from myself here. I mean, if it goes too far, then we can go ahead.
Yes, Your Honor, but if that was the case, I would have just played the entire.
I hear you, but I still think this is a little bit more efficient, but go ahead, Ms. Jones.
And then I would just go back and re-ask the questions. At some point, you did go ahead and read Mr. Little his Miranda warnings, correct?
Yes, ma'am.
And do you recall what specifically you included in that Miranda warning?
Yes, ma'am. We have a little card and we read it verbatim from the card.
Okay, and is it your recollection you read it verbatim from that card?
Yes, ma'am.
But there was certainly some conversation prior to the Miranda warning being given.
I'm sure there was. Yes, ma'am.
1 second, Your Honor. Nothing further.
Okay, Ms. Beja?
One question, Detective Sless, in relation to interrogating Defendant Little about the incident that we're here for today, the January 24th alleged incident of 2022, did that interrogation part happen after Miranda was read?
It was.
No further questions.
Okay, all right, Detective, you're excused.
Thank you very much, Your Honor.
And you'll get me the video?
Yep, yes, sir. Court reporter.
Sure, thank you. Is there anything else left on the reverse Jackson Deno?
No further witnesses for the state as. No further witnesses.
Okay. All right, I will take that under, go ahead, Mr. Carlson.
Nothing on that issue.
Ms. Jones' argument, and the state would have an argument.
Oh, I apologize. I apologize. I'm getting ahead of things here. Okay, go ahead, Ms. Jones.
Thank you, Your Honor. And just for the record, the defense does not call any witnesses in regard to this hearing.
All right.
Your Honor, while the defense will acknowledge at some point Miranda warnings were given, there were statements given prior to that, as well as going to the voluntary and knowingly and the totality of the circumstances in regard to the entire interrogation. You will note in the beginning, and we would point that out to your honor to listen to, that Mr. Little was extremely concerned about going home. He was concerned about his probation violation and whether or not that would hold him. He was.
Wait a minute, just to cut you off.
I'm sorry.
So the statements that were given before the interrogation, you're giving those as an example of his involuntariness.
That's correct.
You're not concerned about them coming into trial per se.
I think it goes to you look at the totality of the circumstances, your honor, and we would indicate that that's it was under the totality, it was coercive. And it wasn't necessarily knowingly and voluntarily given when he is.
That's what I thought. I just, you go ahead.
Our argument, your honor. Very concerned about being able to go home, very concerned that he was going to be arrested. The officer indicated again, prior to the Miranda warnings being given, that this mother needed peace, that he needed to explain whether or not this was an intentional act or it was an accident, to provide some closure. Pizza was given, your honor. However, the client did not have any pizza. And at some point he does read Miranda, and my client does give a statement in regard to that. But we believe just the totality of the circumstances that this was not voluntary and it was coercive in nature.
Okay. Go ahead.
As your honor, no, the trial judge, your honor, must be satisfied by preponderance of the evidence that the confession was freely and voluntarily given, and where Miranda applies, the defendant knowingly and intelligently waives his Miranda warnings. Voluntariness is defined under OCGA 248824. To make a confession admissible, it shall have been made voluntary without being induced by another by the slightest hope of benefit or remotest fear of injury. Your honor, the detective Sluss in this case just testified that during the entire conversation with the defendant Little, and you'll see it on the on exhibit 1, he did not threaten him, force him, offer her the slightest hope of benefit. Often there was not the remotest fear of injury in that. The defendant, and your honor will see yourself, was not coerced in any way. No promises were made to the defendant at all. The defense argued in her argument that Detective Sluss mentioned in the video, yes, I need to figure out if this was intentional or accidental. Of course, Detective Sluss, best practice is telling defendant Little why they are there. Defendant Little was inquiring about probation and this and that. Detective Sluss, as you will see in exhibit 1, narrowed the vision and said, listen, this is why we're here. I need to know whether this is intentional or accidental. Before we talk about that, and your honor will see at 4:25 p.m. in exhibit 1, that's the timestamp of Miranda, 4:25 p.m. Before they even spoke about the incident, the defendant was read his Miranda warnings by card, and the defendant waived the warnings by saying, yes, sir, yes. He agrees to speak with him. He was fully aware of what they were there to speak about. The statement was completely voluntary. And in fact, even during the statement, he was given the opportunity to take a smoke break. And although he did not eat the pizza, it was offered to him and sitting there the whole time. So it's the state's argument, your honor, that the statement made to Detective Sluss was completely voluntary. The slightest hope of benefit was not offered to the defendant. He did not have the remotest fear of injury either. But exhibit 1 was first. Therefore, the state requests that your honor rule the statements that that defendant Little made to Detective Sluss as voluntary pursuant to the state's motion. Thank you.
I feel like I need to ask what kind of pizza it was.
Pepperoni.
All right, I'm just reviewing. Okay, well, I'll review the video in chambers and take that under advisement as well. Now, you said you had witnesses for a Daubert hearing, or it's Daubert. I keep Daubert. Do you have objections to the experts, or?
We will, your honor, yes.
Okay, all right. I just wanted to make sure that was.
Your Honor, the objections need to come before the hearing with all due respect to opposing counsel. We have our witnesses here, but we haven't been served with anything to identify what area of the Daubert standard the defense claims there's a deficiency in here. So we're in a position where we've got witnesses here essentially inviting a fishing expedition, a deposition, and again, there's a procedure under Title 24 for a criminal deposition.
Well, I guess I'm curious, why did you bring the witnesses?
Well, Your Honor, because in the interest of making sure we were as prepared as possible
Okay.
for whatever the court's ruling might be, it would be more prudent to have them here than not. These are also, individuals, one of which was close by. But at the same time, Your Honor, there's no motion, there's no objection. This witness fails on reliability, let's say. This witness fails on methodology. And my understanding is there hasn't been any communication with any of the experts by the defense to root any of those issues out.
Ms. Jones?
Again, I hate to beat a dead horse. I wasn't provided the specific information in regard to my client and his gang activity until September 29th. Now, they can say all they want that they provided me with who they were going to call. But I didn't have the information, so it would have been a fishing expedition for me. And also, when I inquired initially, when the state indicated that they had a memo, she then said she couldn't provide it to me because it was work related or work product, and she'd have to wait until they got it and I'm not really sure what part of that I finally did get on the 29th to figure out specifically what gang this is. I need to be able to talk to my client then about the state's allegations before I can talk to anybody else. It's no different than I need usually the discovery in order to talk with witnesses. I just can't call up witnesses and say, hey, you say that this and this and this, but I don't have what specifically they're charging my client with. And you'll remember we objected when this case was going to be tried in April to the continuance as well as the reindictment. And the state sat on their hands for a very long time to provide me the specific information in regard to what gang that they are saying and what proof they are saying they have. I just don't file generalized motions. I just got this information. Last week, as your Honor well knows, was a very, very busy week for us. I'm certainly happy to file the motions that the state so desperately needs and wants, and we will get that done hopefully by the end of the week.
Your Honor, may I say, we'll make these witnesses available today for opposing counsel to interview, have discussions with, in order to help her perfect a Daubert motion or motions, should they believe they're appropriate. With regard to some of the other matters that were said, I'm not going to respond to those unless the court asks. But I will say right now, we've got a request for a Daubert hearing without a Daubert motion, without anything that's been particularized. That said, we have both of those witnesses here at the close of today. We'll certainly make them available today for an interview.
Well, and I think we all know, we're just discussing the admissibility of these experts. It's not getting into the other factors, but so Mr. Tucker.
Your Honor, I believe in a situation like this, unless the court is wanting to make sure that they are qualified and that they will come in for judicial efficiency, I myself would rather have them on the stand and bring out the deficiencies in front of a jury for the effect of their credibility. So our position's kind of, if we need to have one for the court, we can.
No, you don't. Unless you challenge it, we don't need to have one.
And like I said, I think it would be more efficient for my client and for the case that if he's on the stand and we have concerns, to bring those out so that the jury can make that decision from it.
Okay.
And kind of keep the Daubert out.
Well, why don't we do this then, Ms. Jones, if you're agreeable to this, the witnesses are here, you can talk to them today. And if you so choose, you can file a motion challenging the admissibility of their testimony. Does that work for you?
It can, Your Honor. Like I said, I need to be able to speak with my client in regard to the case supplemental report that I just received on end. And really that I do need to do that first.
Okay. But regardless,
Yes, he has an absolute right to see what the state is alleging and what gang activity they're alleging as well. I shouldn't say gang activity, but what they're saying ties him to gangs.
but I guess that's a separate issue from whether these experts' testimony is admissible, correct?
Yes and no, because oftentimes it's my client's decision to pursue what they can pursue and what not to pursue. So for example, if my client wanted to waive the Jackson v. Deno, that's his right, even though if I say, don't do that. So if he doesn't want to pursue a Daubert, he has a say in that,
Okay.
if that makes any sense.
Well, counsel, do you object to continuing the possibility of a Daubert motion in the future?
No, Your Honor, we do not. I would add that we have, sorry, Your Honor. No, we do not, Your Honor. We recognize opponents of counsel may need to prepare for that. That said, we are ready to proceed with merely the qualifications of these witnesses that would come before a tender, which is what Rule 702 would require in terms of the Daubert aspects of it. On that issue, Your Honor, so I do have what I'm going to show to opposing counsel now is State's Exhibits 1, 2, 3, and 4. Exhibits 1, 2, 3, and 4. I'm taking those to opposing counsel right now. And what it is the resume and CV of Captain David Teeler, who would have been one of our witnesses today, depending on how the court goes forward. The opinion, brief summary opinion that was provided to opposing counsel. Both of these were provided in discovery of Captain Teeler, his opinion. That's 2. So 1 is the CV of David Teeler. 2 is the summary opinion of David Teeler. 3 is the resume CV of investigator Aubrey, Aubrey, Lyda. And State's 4 is investigator Lyda's summary opinion. These were provided in discovery, but we did want to make them part of the record today. I'm showing those to opposing counsel.
Yeah, double it, you just want us to share. I've already got mine in discoveries.
And I'm advised this is what was sent out in discovery by co-counsel.
And I'm saying it's really more for your client's benefit, Ms. Jones. I mean, it's not necessarily whether you agree with the expert. I mean, although reliability in their methodology comes into play.
Right.
It's just, I'm acting as a gatekeeper to whether the jury even has an opportunity to.
Right, and the rules of evidence changed in regard to Daubert not
Yes.
too long ago, so
Yeah.
it's all new waters, so to speak, uncharted waters.
And so, Your Honor, again, opposing counsel needs more time to confer with their client.
Definitely is. I mean, we're relying on a lot of federal case law even for it.
And in
so.
fact, Your Honor, for the record, the federal rules changed slightly in December. So that's going to add an additional wrinkle for all, maybe perhaps not in this trial, but another. I'm going to tender then States 1, 2, 3, and 4 as described before for purposes of this pre-trial matter, Judge.
Okay. Ms. Jones, any objection?
No objection.
All right.
And-
So tendered.
Admitted into evidence, Judge?
Yep. Okay, is there anything else we need to take up then?
We're especially set for November 13th.
Yes.
I know that the state is ready. We got a case on November 13th. As a vacation at some point, but some acts, we might have to end early one day, if Your Honor would allow. That's why the next day. I'll get the dates on our email, Ms. Robinson. But
When we get closer, we can talk about the scheduling, how long we think it will take, and then I'll double whatever you tell me. And
I'm usually accurate, Your Honor.
yeah. All right, Ms. Robinson reminded me final plea is the 11th for it. Is there anything else? Ms. Jones, Mr. Tucker?
Maybe the only time this trial I'll be quiet over here.
Ms. Jones?
Yeah, Your Honor, I would only note that Mr. Vernon Spear was specially set for his competency on, it looks like 11/6 through the 9th, and then jury trial is scheduled for 11/13.
Vernon Spears, another case of mine.
Yep.
That I'm well aware of, that Miss Jones is on as well.
Yes, and that was just specially set not too long ago. So I'll be juggling those two.
I guess as
But
we
it's
get
just here,
closer,
ready.
so unfortunately, I can't say we'll let the other judge worry about it.
But I mean, both will be ready. Spear's been ready for a real long time.
Yes.
Just competency.
Yes, Mr.
But that's all I got.
Okay, and so are you going to take the opportunity to try to speak to these expert witnesses now, or do you, or will you do that in the future? And
I'll make sure that I've got good phone numbers. It looks like they were on their,
I guess that's your business, not mine.
yeah.
As I think about that. But obviously, we need to know fairly soon if you're going to object to the admissibility of the testimony. With that, we are adjourned.
Thank you.